Very good, Lordship. This is my Lord 2023 matter and last posted on 22nd of November 2024. Reading completed, my Lord. Matter may be listed on 8th of this month.
Next, after you.
So I will put after Bihu.
My Lord, item number 35, my Lord. Here in this case, government has filed, my Lord, affidavit in opposition. We have to file, my Lord, counter. My Lord,
Okay. How much time?
my Lord, 1 week time, my Lord, after Bihu vacation.
Okay. Mr. A. Manna, Learned Counsel for the petitioners, has prayed for and is granted 2 weeks time to file an affidavit in reply to the affidavit in opposition filed by the state respondents. First of Ms. S. Borwal, Learned Junior Government Advocate Assam, and Ms. G. Hazarika, Learned Standing Counsel Revenue for the state respondents or Revenue Department are in attendance.
Please, Your Lordship, with respect to item number 33, we require some time to file our affidavit. I've taken the consent from the other side.
Okay. Mr. K. Jain,
Lordship.
Learned Counsel representing Mr. S. C. Kyle, Learned Standing Counsel CGST, has prayed for and is granted how much time?
3 weeks, Lord.
3 weeks time to file a counter affidavit on behalf of the respondent GST authorities. It is submitted that consent has been taken from the Learned Counsel for the petitioner to make the prayer.
Lordship, interim order. Regarding this.
Huh?
Interim order.
The interim order. You are there, Mr.
R.K. Mohanpur.
R.K. Mohanto, Learned Counsel for the petitioner is present. Huh? Consent interim order.
May I please, Your Lordship, my Lord, item number 32, my Lord, Your Lordship may remember, this is a PRC matter, my Lord. My Lord, in this case, my Lord, I am going to file an interlocutory application tomorrow, my Lord, because her admission has been halted because of PRC, my Lord. So matter may be taken in the next week, my Lord, along with the IA, my Lord.
Okay, Mr. A.H.M.R. Chaudhary, Learned Counsel for the petitioner, has prayed for listing of the case in the next week. It as the prayer is not object to by the Learned Counsel for the official respondents, list the praise allowed, list the case in the next week.
My Lord, another prayer, my Lord. My Lord, pertains to delimitation, my Lord, woman reservation, my Lord. Matter was fixed in the last week, my Lord, but due to paucity of time, matter could not be taken, my Lord. If possible, my Lord, tomorrow, my Lord. Otherwise,
Tomorrow, Monday.
then, my Lord, Tuesday, if matter can be disposed of on that day, my Lord.
You list it on Monday?
Obliged.
May I please, Your Lordship, I beg to mention for listing writ petition for motion. All the matters, 4 numbers of writ petition, all the matters related to DRC 01. It is covered by Your Lordship order.
So it will be listed definitely.
It's fixed for tomorrow, Lordship.
It is fixed for tomorrow.
No, list for tomorrow. Can we
Motion?
list for- Yes, Lordship.
No, it will come automatically. Will not praise the registry.
Maybe, Lordship.
Okay.
Prayer for listing, Lordship. For motion, Lordship. 2 writ petition for motion, Lordship. Delimitation matter, Lordship. Delimitation.
Next week. It will come automatically.
Another prayer, Lordship. Admission matter, Lordship. Last listing on 19/1/24, Lordship.
After Bihu.
After. Okay.
May I please, Your Lordship. Lordship, I beg to mention item 25.
Yes.
Some outstation advocate is engaged in this matter, and today morning we were informed that his mother has been taken to the hospital.
Okay.
Lordship may take up the matter on Monday if Your Lordship pleases.
Okay, on the prayer of Ms.
P.K. Khakholia.
Pakolia, Learned Counsel for the petitioner.
May I please, Lordship, the name of Mr. S.C.K. as Standing Counsel CGST should be reflected.
Okay. List the case on Monday. Mr. K. Join, Learned Counsel, submitted that the name of Mr. S. C. Cal and Standing Counsel CGST be reflected in the cause list. Office to reflect the name of Mr. S. C. Cal and Standing Counsel CGST in the respondent side the cause list.
Much obliged.
Daily list for withdrawal. Item number 1. Lordship, owing some defects, Lordship, I like to withdraw this.
Mr. A. Islam,
Lordship, kindly may grant liberty to file it afresh.
Learned Counsel for the petition has submitted that some inadvertent mistakes have crept in the writ petition. And so he has therefore prayed for withdrawal of the writ petition with the liberty to file afresh. Ms. Z. Hazarika, Lion Standing Council Revenue Department for the response number 1, and Ms. S. Borua, Junior Government Advocate Assam for the response number 2 and 3 are present. In view of the above submission made by Mr. Islam, Lion Council for the petitioner, the writ petition stands dismissed on withdrawal with the liberty, as prayed for.
Item 52.
May I please the lordship? I have withdrawn the matter, lordship. I have withdrawn the matter, lordship.
You want to withdraw?
Yes, lordship.
Okay. Mr. P.K. Gogoi. You received the money or what?
Already petitioner sold the vehicle, lordship.
Huh?
Yes, sir. So, sold up.
Very good, lordship.
Okay. Mr. P.K. Gogoi, Land Council for the petitioner has submitted that the petition, submitted on, on instruction, that the petitioner doesn't want to pursue the writ petition. First of Mr.
And for response number 2 and 3.
2 and 3.
For response number 1.
Miss
And they on behalf of Arthur.
R or L Day. Day.
They and
Miss L Day, Land Council representing Mr. R or Land Standing Council. Welfare of Plain Tribes and Backward Classes Department for response number 1. And Mr. A. Chetri, Land Council, appearing for the response number, for the response number 2 and 3. 2, 3 and 4 also are present. First of, in view of the above submission made by Mr. Gogoi, Land Council for the petitioner, the writ petition, having been withdrawn, stands dismissed.
53. May I please, the lordship? Comply to the lordship. Relief has been granted.
Mr. S.I. Akan, Land Council for the petitioner, has submitted that the order,
17/7/20.
the direction in the, there has been an order dated 17/7/2023, in respect of which this contempt petition was prepared, has since been complied with. Full stop. Ms. P.R. Mohanto, Land Council for the response number 1, has also endorsed the said submission. Full stop. In view of the above submission made by the Land Council for the parties, this contempt petition stands closed.
So, for motion, item number 2. May it please your lordship. Lordship, here the issue is, my lord, the land which was acquired, my lord, that was sold.
So
by deed of
your
sale.
award is not given, copy of the award, and this respondents are shown as beneficiaries.
Yes.
Then we'll issue notice. Heard Mr. M. Dotto, Land Council for the petitioners. G. Hazarika, Land Standing Council, Revenue Department for the response number 1. S. Borua, Land Junior Government Advocate Assam for the response number 2, 3 and 4 posters. Where in this writ petition, the petitioners comma 12 in number have projected that their predecessors in interest purchased a parcel of land measuring 12 bighas, 1 katha, nine lesser, comma, covered by tag numbers 201, 202, 207, 211, 264, and 265, and periodic pata number 70, comma, situated at Sildubi Pathar, Gaon, comma, Moja Kaziranga, Bokaghat Revenue Circle, District Golaghat. Subject plot from one late Krishna Bahadur Chetri. Post of the respondent number 5212
12.
are legal representatives of late Krishna Bahadur Chetri. Post of paragraph. The petitioners have further stated that the subject plot was purchased, though the subject plot was purchased in the year 1970 by way of a registered sale deed dated 17/3/1970, comma, the and position of the subject lot was handed over to the predecessors in interest of the petition. The subject land was not mutated in favor of the petitioner in view of a process of land acquisition initiated by land acquisition case number 4/1989-1990 for acquiring land for the project quote, second addition to Kaziranga National Park. First off, as a result, the name of late Krishna Bahadur Chetri is still reflected in the records of rights in respect of the subject plot, whereas the petitioners in interest and subsequently the petitioners are having the right title, interest, and position over the subject land. Full stop. When the matter of determining compensation in land acquisition case number 4/1989-90 arose, comma, the land acquisition officer issued notices to the petitioner side as well as to the private respondents hearing to receive the compensation amount determined by the land acquisition officer. So, according to petitioners, the petitioners are made entitled only to Zirat compensation amount of rupees 41,04,528, whereas the private respondents, in respect of the private respondent, comma, the land acquisition officer has purportedly shown an amount of rupees 81,35,517. Postal. The private respondents, the petitioners have claimed that the private respondents have submitted 6 number of affidavits declaring that the subject land was already sold by their predecessors in interest, namely predecessors in interest to the predecessors in interest of the petitioners. Postal. As the land acquisition officer is offering the amount of rupees 81,35,517 Still to the private respondent, the petitioner thus submitted a representation before the respondent authorities post of having received as the issue has not been decided by the respondent authorities, more particularly the land acquisition officer, the petitioners are before this court issue notice returnable on so and so date as so and so has appeared, accepted notice on behalf of the so and so, issuance of formal notice to the said respondent stands dispensed with. The petitioner shall take steps for service of notice upon the respondent number 5 to 12 by registered post with AD within 2 working days from today, post of having regard to the projection made in the state petition, and more particularly, and assertion made to the effect that the private respondent number 5 to 12 have already submitted 6 number of affidavits declaring that they have no claim in respect of the compensation amount, it is provided, in the interim that the respondent authorities shall not disburse the amount of rupees 81 lakh. $35,517 till the returnable date.
My lord, in the interim, my lord, Jirat amount, my lord, 41 lakhs, my lord.
That I don't know. That is up to him.
That may be directed to.
He will decide. So far, private respondent is concerned, let them come.
That is, my lord, I am agreeable, my lord. But my lord, in regard to that, my lord, 4 notice by way of which, my lord, we have been offered.
I have
21
not
lakhs.
observed anything. You go and agitate before that. We don't know the clear picture. We don't know the clear picture. If he is ready and willing, let him disburse. We have stayed only 81 lakh.
My lord, I may
On
be-
the motion day, Mr. Lotto, don't pray for unreasonable. We have stayed the private respondent's part.
Yes.
You were saying that there is no dispute about 41 lakh. Get it. On the first day, on the basis of the affidavit, let them come.
Obliged. Item 3.
The standing council election
War.
commission.
Please call Mr. Kumar, K. Kumar.
Item number 4.
Mayor, please, your lordship. My lord, this is,
Tell me how it's counted.
my lord, lordship, kindly.
We are not.
My lord,
Mr. Sinha
my lord,
will observe something.
my lord, kindly see, my lord, page 20.
We have all seen.
Yes,
What
lord,
is
here.
there?
page 20, my lord, page 28, my lord. Page 28, my lord. Para 20, my lord.
No, see the observation first, last
My lord.
operating part.
My lord. My lord, page 30,
Ah.
para 26, my lord.
Page 25. Page 26. Sorry, para 26. Before page 25.
My lord. My lord.
Then page para 26. Before parting with the record.
Yes, ma'am.
Read.
The court is inclined to clarify that this court has not adjudicated the right title and interest of any of the parties to this writ petition, and therefore, if there is any inter-se dispute between the parties with regard to the title or ownership of the said land or right of the railway authorities to evict the enclosure, the respective parties would be free to approach the competent court of law or an obligate court forum, as the case may be.
Yes. Then
lord.
come to your pleading.
My lord.
Come to your pleading.
My lord, then already,
Come to your pleading.
my lord,
Para 6.
my lord,
You have said so.
my lord,
Then para 7.
my lord. 123, my lord, already,
Para 7.
my lord,
Petitioner humbly submits that in compliance of the High Court Direct Order 86/2023, the Revenue Department duly completed the demarcation process and passed an order on so and so, observing the findings of the demarcation, right?
my lord,
Then further. However, on so and so 23/2025,
my lord,
suddenly came, dismantle or demolish the boundary.
my lord.
Now read once again the paragraph 26.
My lord, yes, my lord, here, my lord, and Losime,
If
that's what-
railway has done some illegal thing after demarcation, the court has only ordered for demarcation,
yes, my lord,
nothing else.
nothing else.
Now, how contempt?
My lord, no, no, but that's why I'm coming, my lord, before this court. In this case, my lord, they are demanding, they're seeking for demarcation only. So dishonorable
No,
court,
whatever the direction of the court
my lord, kindly, see-
is for demarcation.
yes, my, and my lord,
Then thereafter, right of railway authorities to evict the encroacher, if there is
per
any
SW
interstate dispute between the parties with regard to title ownership of the said land or right of the railway authorities to evict the encroacher, the respective parties would be free to approach the competent court without approaching the
yes,
appropriate court.
yes,
The railways decided to go to your plot and demolish.
my lord.
This is not within the scope of contempt.
No, my lord, kindly see.
I am
Already,
causing you file an appeal.
my lord,
Don't misuse contempt.
no, my lord, here,
That's all. You're pleading.
my lord, yes.
That's
My lord,
all.
kindly see para 21, my lord. Here also it is stated, my lord.
What's stated?
My lord,
Which
kindly see.
paragraph?
In respect of WBC number so and so, this is filed by railway, my lord. It is clarified that the land revenue staff attached to office of Deputy Commissioner Kamrup Metro Court is only required to demarcate the boundaries of the railway lane in
For
terms of-
high-handed action, you have to file a writ petition.
But definitely, my lord, no, already, my lord, this is the second round of litigation, my lord. Already, my lord, demarcation, my lord, kindly see the demarcation order, my lord.
No, I will only see your statement.
Definitely, my lord, already after
We are not
demarcation,
going into that.
no, my lord,
Please come to paragraph 7.
my lord, that's why I'm saying, my lord, after demarcation, they suddenly come, my lord, here
This part is high-handed action on the part of the railway authorities, right? And that was not part of the direction of the honorable court.
yes,
Honorable court's direction was to demarcate.
only,
It was limited to it.
yes, my lord.
Demarcation was done. Thereafter, railway authorities ought not to have gone to your Pataland, according to you,
My lord,
right? That is a high-handed action.
Right.
That cannot be, that is not the direction of the court. Direction of the court is only for demarcation, and which you have stated clearly, the demarcation was done
done, my lord.
according to, in compliance with the direction of the court. This is beyond that. This high-handed action of demolition by the railway authorities going to your plot of land is beyond the direction,
Direction, my lord.
right?
My lord.
This is, if you say it is high-handed action, there could be a writ petition,
My lord.
but not contempt
My lord,
petition.
only why I'm filing
Why
this, my
not?
lord, para 26, my lord, kindly see, my lord.
I have read and
My
read.
lord, para 26, it is an observation, but there is an observation that
I have
regarding-
understood.
my lord,
Mr.
regarding any
I
enforcement,
tried to understand.
my lord,
What? Please lead.
my lord,
If it makes out any other meaning,
no, my lord, kindly para 26, my lord.
if there is,
There is-
if
yes, if-
there is any interstate dispute between the parties with regard to title or ownership of the said land or the right of the railway authorities to evict the encroachers, the respective parties will be free to approach the competent court or forum as the case may be. But despite existence of dispute, the railway authorities, instead of going to the court,
Yes.
decided to go to your place and
My-
demolish it.
my-
This is writ petition.
my lord, my humble praise, at least, my lord, this is the writ petition-
Absolutely not.
My lord, writ
At least
petition-
this
my lord,
court.
writ petition filed by them. not by me, my lord.
Whatever.
In that writ petition, my lord, this honorable
Heard
court has
Mr.
observed, my lord,
Kesina.
something to, my
No,
lord,
I am closing it. This is not content.
my lord,
We
then,
cannot draw them.
my lord, then I may be allowed to.
This
withdraw,
is amounts to abuse.
my lord, then I may be allowed to withdraw, my lord. With liberty, my lord.
What liberty?
My lord, to
No
file-
liberty.
my lord, then-
I'm observing, no liberty. Again, before another court, absolutely not.
No, liberty to. file a-
Somebody will not read it,
No, my lord,
will not read it, issue notice, then another process comes.
no,
No,
my lord, my prayer for liberty is, my lord, to file a fresh writ, my lord.
that is different thing.
Yes. That is,
That is different thing. But no contempt.
let me allow to withdraw.
Okay. Heard. Mr. K. Sinha, Learned Counsel for the petition. The instant writ petition, instant contempt petition is preferred against alleging non-compliance of direction made in a common order dated 8/6/2023 passed in writ petitions cover WPC number 1838/2022 and WPC number 1907/2022. First off, by the common order dated so and so, the court had directed the respondent authorities to carry out a demarcation process in respect of the lands the petitioners in the two writ petitions had claimed. Full stop. Para. I perused the common order dated so and so, contents of the common order dated so and so, as well as the pleadings made in its contempt petition. Full stop. There is a reference to an action to an incident dated 23/2025. Post of Mr. Sinha, Learned Counsel for the petitioner, has submitted that the incident occurred on so and so was a high-handed action on the part of the respondent railway authorities. Post of para. After I have heard Mr. K. Sinha, Learned Counsel for the petitioner,
No, my lord, only one.
petitioner has some length. Post of para. Mr. Sinha, Learned Counsel for the petitioner, has submitted that the petitioner would withdraw the instant contempt petition in order to seek available appropriate remedy before the appropriate forum against the incident dated 23/2025. In view of the above submission made by so and so, the contempt petition is dismissed or has not pressed, liberty however stands reserved to the petitioner to avail appropriate remedy
My-
before appropriate forum as regards the incident, alleged incident dated 23/2025.
Obliged.
Item number 5.
May it please your lordship, can matter may be passed over for typing lordship. My senior
Already we
counsel-
have the instruction, but the petitioner's claim was that they need to get the compensation, but from what we have found out and from the records that has been done. So they are only Khatian holders. They have been occupying the government khas land. And as per the Tenancy Act of 1971, they need to have an agricultural activity, but that no such activity has been done by the petitioner or any other.
But suppose Khatian holder is there, what kind of, are they no person interested?
No. For that matter, as per the Tenancy again Act, they have to go into. the
File your
agricultural
affidavit, so
activity.
let Mr. Chaudhary come,
So we will file the affidavit.
but the interim order may continue. If they are Khatian holder at least, they have some kind of interest there.
Khatian holder only, but
Ah.
there's no agricultural activity being carried out by any of the family members of.
Okay. But what kind of are they
Let me-
not
let me-
personal interest, personally interested?
There cannot be.
May not be owner,
There cannot be any personal interest.
person interested,
Person,
no personal interest. I am saying about the statute.
happy, sir.
Item number 6.
Any instruction? Or will issue notice?
Yes, we have got a detailed information.
Here, my,
Huh?
here, my, that, where is the board?
Hello. Fifteen to 2025, other was facing for very probably.
File your affidavit thereafter, we'll see.
But
We don't know who have misconstrued. The petitioner or the deputy commissioner, we don't know. Let the affidavit be filed. Heard. Mr. S. Sahu, Learned Counsel for the petitioners, P.R. Mohanto, Learned Standing Counsel, Revenue and Disaster Management Department for response number 1, and Mr. S. Borua, Learned Junior Government Advocate Assam for response number 2 and 3. Both Ms. Mohanto and Mr. Borua have submitted that they have received instructions in a matter, and the counter affidavit will be filed within 3 weeks' time. 3 weeks?
Yes.
It'll be worse, no? 4 weeks. Okay. Issue notice returnable and so and so.
5th May, 5/7.
As Ms. Mohanto and has appeared accepted. Borua for 2 and 3. Issuance of formality stands dispensed with it. Extra copies within 2 working days from today.
Item 7.
Lordship, my senior is in another court. Kindly timing the matter.
Item number 8.
That's for your lordship's last one.
Yes, Mr. Borua.
I think that is for item number 8. Now.
It is going.
Yes.
The fake document.
I think the issue is with regard to an order of cancellation, perhaps,
Yes.
page
Yes, page
51.
51.
The findings of the investigation is there. Makes it
Hmm.
clear.
No, question is not that. You may have a valid point. Mutation was granted in favor of the petitioner by two orders, right?
Yes.
One order or two orders, at least 2010, 2022.
2010, 2022 was in favor of my predecessor in interest, and thereafter 16th of July 2023 was in my favor.
That is mentioned here in this order.
Uh, it inadvertently in your lordship's first order, that 16th July got inadvertently left out. It is there on the file, and I
No, we are not on the file. We are into the contents of this order.
Oh,
51, please.
Yes, yes, your lordship. Your lordship
Which
will
one?
see-
Which part?
Your lordship will see the second paragraph.
RTPS?
RTPS.
That is.
That is fine.
Okay. So if the mutation orders have been passed, if something revealing comes up, additional material, because these are also, mutation order is also under Assam state, some land and revenue regulation,
Yes.
exercising statutory power. Right? And even if you say it is Assam Right to Public Services Act, then it is to be recalled whether in notice minimum, then notice prior notice is not necessary
That is a basic requirement, yes.
because
That
he is acting on the basis of some investigation report or another part, advice of the circle officer.
Not
No,
even the,
no,
not
circle
even the
officer
report.
is doing it based on the letter from the Commissioner of Crimes.
Huh,
Whereby this force
right.
documents has been.
Circle officer advising it. And the Deputy Commissioner Superior Authority is acting it on it. Without,
On the basis of a letter, even before charge sheet has been filed.
where is his reflection of mind?
No, no, sir. No, none at
But,
all.
but where is the notice, man? Sir?
Notice is another part,
Then-
but as regard the other part, that's.
See your instruction.
DC is.
See your instruction.
Yes, instruction very well says
Ah.
that the deputy commissioner has asked the circle officer to go for cancellation.
Ah.
And that has been done based on the letter.
See the
from
last
commissioner.
time. We have simply asked, yes, you have the power, maybe. We are not,
It is my submission that even under the Assam Land and Revenue Regulation.
let
it
us
is not-
assume for a moment, we are in the motion state. We'll go into detail later on. Is it not violation of principles of natural justice? Even if it is a mutation order?
Yes. Or.
Last line,
It is the 8/3/2000. Which order you are looking at?
this 51,
8/50.
this is the impugn order?
Yes. One of the impugn orders.
Yes.
Report or not, he may give
No,
a report, that
I-
is not.
I will leave my
So report
prayer
of
on the report, but your lordship-
Commissioner of Crime, Joint Commissioner, he may give
Absolutely.
report.
Absolutely,
That is a different issue altogether.
absolutely.
For that,
I bow down to your lordship
But
on
we
that.
are into this only, this is 8/3/2000.
8/3,
8/3,
2024, and the consequential action taken by the circle officer, which is at page 52,
So
where my name has been
constitution is
deleted.
different thing. Yes, sir.
But this is in motion space. Let us put our contention by way of.
But in the meantime, this should be suspended. Because admission is there. No, any notice has been served upon the petition.
So lordship, can it be taken up tomorrow? Because just now I have received the instruction. I couldn't raise the matter thoroughly. So let me have my,
Yes, tomorrow.
Lord, the difficulty is that
only
I-
for a day.
I jump at the opportunity of appearing before your lordship, but
Because
unfortunately I come from
ultimately,
Delhi.
Oh,
So-
he is from Delhi.
So matter may
And
be
that is
taken
why
up,
he has come thrice.
matter may be taken up in the afternoon, and my learned friend can seek his instructions.
At 2.
There are many litigations. We are not concerned with that. But question is, if he gives an opportunity to the petitioner, you take also instruction that if he wants to recall it and issue prior notice to the petitioner, give hearing and pass a fresh order, no issue. We are not going into any of the merits because this might disturb the surrounding legal proceedings. Take your call. But the stay will affect many other interests. Take your call. If you say it, you want to withdraw it and to follow proper procedure and pass a fresh order, giving notice to the petitioners who is likely to be affected because mutation order was in favor of the petitioner.
That was.
So behind her back, this has been done and which is having civil consequences. So ex specie,
No, that is what
take
the
your call, take your
investigation
call.
is.
It is up to you. Ex specie, subject to your rebuttal.
Ultimately, the forgery might not have been traced out at the point of.
No, that is, we are not into that. We are not into that. Yes, if it is forgery, why don't you put the petitioner on notice? See, this is forged.
So that. I-
Personal hearing, personal appearance, pass the order. Then it is an appealable order.
Yeah.
Not through the writ petition.
I'm only concentrating on that.
I am only, this court is only concerned with that.
Item number 9.
Deeply grateful.
No instruction. Huh? We have to issue notice. We have to issue notice then. It cannot be expedited. We tried to expedite it. But
Maybe another date.
No. we not want to keep it in motion. I think, twice I have put it
Yes,
on motion.
and all things are before your lordship.
Heard Mr. K. Ahmed, learned counsel for the petitioner, Z. Hajorika, standing house revenue. Response number 1, Mr. P. Hajorika, learned counsel, representing Mr. R. K. Musahari, learned standing house BTC for response number 2 and 4. NMS S. Moore, learned junior government advocate Assam for response number 3. Despite granting two opportunities,
Kilometers are there.
despite
number
granting two opportunities to the learned standing council BTC, comma, the learned standing council BTC has submitted that he has not yet received any instructions in the matter as to why the application for mutation, comma, submitted by the petitioner on
31st.
31/8/2024
Well.
has not yet been brought to a logical conclusion. First, para issue notice, returnable insolvency, as so and so appeared, accepted. issuance of formal distance dispense with extra copies by within 2 working days. It is observed that pendency of the writ petition shall not be a bar for the respondent authorities to process the application for mutation stated to have been submitted by the petitioner on 31/8/2025 in accordance with law.
My lord, relating to respondent number 5 and 6, private respondents is there.
Is there?
Yeah, my lord.
Okay.
Who are the
Take
landowner?
steps. Shall take steps. 5 and 6, huh?
Item number 12 is also similar.
Same, my lord, application date is same also.
Application date is same.
My lord. And parties are also same.
Parties are
Okay.
same. Private respondents are there.
Private respondents are same. Petitioner are same.
But my lord, I am appealing on that behalf, on behalf of SR, on that.
Okay, SR of RK summary, no, RK summary. Okay, same day. List this case along with WBC number 7. Last one, Likidio.
Obliged.
Item 10,
এই চেঞ্জ ওটা তো করবা মজে ডিসপোজ করেছিল নাই দেখুন এটা Yes,
Lordship, on last date, Lordship directed.
I indicated.
yes, instruction.
But that because of that order, Lordship, we have not initiated any steps, Lordship. We are
Ah.
not issuing any notice at this stage.
Ah.
So Lordship will either grant me some time to file a detailed affidavit, Lordship. Or Lordship will,
I really get, we are not here going into all this,
yes, then in that situation.
all
Lordship,
this
because of-
mother-daughter dispute. Is it not?
Yes, Your Honor.
Mother-daughter
Although it is
dispute.
a mother-daughter
Let,
dispute,
let them file appeal.
Your Honor,
Yeah.
but there is a strict violation of law, Your Honor.
That will be examined by the,
I'm sorry.
if it is an appellate order.
Or not. In this case, Lordship, my instruction I have not yet received, Lordship, and I am expecting within 1 hour or 2, Lordship.
Okay,
So if Lordship. prefers
after the
that
motion,
At 2, Lordship.
okay, after the motion.
Lordship.
Which one I? Hey, or more it or like what? Demolition of yes. What is,
In this
yes,
case, Lordship, I was submitting.
okay,
On last date, Lordship directed not to take any, coercive steps, Lordship. So we have not initiated any 337 proceeding, Lordship, although the notices are ready.
ready.
So if Lordship disposes of this matter, Lordship,
Then Lordship may direct them to comply with the procedure established under law.
Huh?
I'll respond to it. And in the meantime, let them not take such actions that they have already resorted to.
Okay,
without.
so you know the law,
Yes, I
all these re-demolition, everything you know
understand.
nowadays. So you can take any breach,
Lordship.
you avail appropriate remedy.
If some indication in the order, your Lordship.
Ah.
Because once there was already an observation by a coordinate bench, even after that, they chose to come at night and then undertake this exercise.
Generally
some
come at
access-
night because that area is so busy, Lordship.
No, because your Lordship will
It is not
kindly,
possible to use any.
a coordinate bench of this court, in fact, has held that such demolition exercises conducted at night,
Okay.
that is not perhaps in tune with the rule of law.
Nowadays in metro, this happens. Okay,
So some observation, I'm only praying for that.
I've heard Mr. K.P. Pathak, counsel for the petitioner, and Mr. P. Nair, the standing counsel is GMC, for the respond number 1 to 5. Post of. The petitioner stated that he is a tenant of an iron structure shop measuring about 300 square feet, located at Latokia,
Latoki.
Guwahati. And he is in occupation of the said tenanted premises on the strength of an agreement, rental agreement executed with the owner of the said premises. Also, the petitioner's further stated that he has been operating a garment shop,
It's a garment shop.
from the said tenanted premises in the name and style of Alam Traders after obtaining all the requisite permission stroke, certificate stroke, licenses, etc. Full stop. Para. This is CRP or what? The other one?
The other case, it's a writ petition. my lord.
Writ petition.
Writ
Okay.
petition.
Who are these petitioners?
Your lordship, this petitioner
Ah,
is another tenant of my landlord. They have some other dispute. So,
okay.
yes,
The petitioner has stated that two other tenants under the same landowner had initiated a proceeding. Had instituted a writ petition, WBC number 6119 2024. Alleging certain arbitrary action on the part of the respondent, Guwahati Municipal Corporation authorities. The said writ petition, after hearing the learned counsel for the parties impleaded therein, was disposed of by an order dated 18/12/2024. Post op.
it was not disposed of.
Not disposed
Not
of.
disposed.
Oh, okay. Okay. An order. Sorry. In the same repetition, during the deliberation, in the course of deliberation of the said repetition on 18/12/2024, which led to an interim order
Interim order.
dated
Interim.
18/12/2024. The occupation of the tenanted premises by the petitioner had also cropped up post of by the said interim order dated 18/12/2024. The court had observed that the respondent number 3 and the respondent number 4 therein would ensure the removal of the obstruction on the eastern side and to ensure entry and exit to the southern side within the stipulated period without affecting, you are Muhammad Alam,
I'm Muhammad. Ali.
without affecting the kiosk of Muhammad Alam. Full stop. Para, in the order dated 18/12/2024, comma, the court had further observed as under paragraph 14, page 50. Para, the petitioner has approached this court by an instant writ petition alleging high-handed action on the part of the respondent GMC authorities by stating that on 18/3/2025, the respondent GMC authorities had carried out a dismantling exercise whereby the iron frame standing in front of the petitioner's tenanted premises within bracket shop had been dismantled and taken away, without issuance of any prior notice, as observed in paragraph 14 of the order dated 18/2/2024. Post office. When the writ petition was moved on 26/3/2025, this court, after hearing the learned counsel for the parties, had observed in the interim that till the next date of listing, the parties shall maintain status quo existing as on today. Post up. Existing on that date. Post up. Thereafter, on 28/3/2025, when the case was listed again, the respondent GMC authorities were asked to ensure appropriate preservation of the iron frame stated to have been dismantled from the petitioner's shop and to maintain status quo. And the parties were asked to maintain status quo existing on that date with regard to the shop of the petitioner. Para. Mr. Nayak, standing counsel GMC, has submitted that since there appears to be certain violations in the operation of the tenanted premises, rented out to the petitioner by the landowner, and the petitioner is operating from the said tenanted premises, the respondent GMC authorities are contemplating to issue proper notice in terms of the observations. Paragraph 14?
Yes, sir.
In terms of the observations made in the order dated, made in paragraph 14 of the order dated so and so, passed in the writ petition. Post up. Para. Mr. Pathak, learned counsel for the petition, has submitted that in the event the respondent GMC authorities proceed in accordance with law and issue a notice to the petitioner to afford proper and effective opportunity to respond. The petitioner would respond to the said notice. Post up. In view of the submissions above submission made, in view of the submissions made by the learned counsel for the parties in the aforestated manner, this court does not like to make any observation with regard to the respective claims of the contesting parties at this stage. Post up. Having regard to the observations made in paragraph 14 of the order dated so and so, passed in the writ petition, and the and considering the fact that the GMC authorities are contemplating to issue a notice in compliance of the same, this code of is of the considered view that instead of keeping this writ petition pending, the same can be closed, it is accordingly closed, while parting with, this court is of the considered view that while issuing notice, after issuance of notice to the petitioner or any other person to the petitioner, the petition should be given a proper and effective opportunity to respond to the said notice. And the proceedings so initiated should be brought to its conclusion in accordance with law and as per, in accordance with law and as per, by following the principles of natural justice.
Very good.
Till the balancing the equities, it is observed that till the disposal of the proceedings to be initiated by issuance of a notice, the parties shall maintain status quo as on today,
Very good.
as on today.
Very good.
The meantime, he has already erected.
Is it?
No, I have already disclosed to your lordship. Before filing of the petition only, I had disclosed it, your lordship. Photographs are there in the petition.
Okay.
It is there. I am operating it as it
You
was.
keep the iron frame.
Iron frame is it there?
I am not observing anything on merit. You contest it.
This can be issued in respect of the present structure.
Yes. Any violation of the.
Any violation, I have said
violation.
any violation. I have said certain violation you have noticed, so you indicate the violation.
Item 13. 13 and 54, my lord. My learned friend was supposed to obtain inspection.
Yes.
There is no such concrete proposal after the fire started. As on date, there is no such concrete proposal.
And what is this allotment procedure by the other process out of that judgment passed in the 3 writ
And
petition?
notice has been issued, my lord, that all these persons who are occupying the 33 plot, 33 PHC to the houses, my lord, notice have been, they are supposed to take, after the notice, 30 days left of notice, they are supposed to evict this person. In the meantime, there is a lot of conduct staying.
Yes, now that is why I am asking.
At the same time, on those place, my lord, where the person where that fire took place, as of date, there is no such concrete proposal to start a house. for
So
this.
these are your people, generally
But
he is
these are-
saying, I don't know, he is projecting
But
that they don't get.
There are other set of persons who have filed before, who have come before the court. And to allow this, they are entitled to this 33 plots, 33 houses, my lord. But petitioners were only temporarily allotted.
Right,
They
that I
have to
understood.
leave.
That I have understood. So any of, that is why I
There is
had
no
asked
such-
you
there
that,
is no such alternative,
so where they would go, otherwise.
because in the file entering into these 33 houses, they have given an undertaking, the outcome of the writ petitions, through writ petitions, they have to leave.
Okay, you place those,
Because I'll
those,
put it on affidavit, my lord. In the while going, so you have.
so you place immediately after Bihu.
What?
Will issue notice.
Ma'am.
You place those, then if you have entered into these accommodations with an undertaking, then
Those
you have to abide by that undertaking, irrespective of. Heard Mr. A. Goel, Council for the Petitioners, as Bora, Standing Council, ZDD stroke ZMC for respond number
1, 2, 3, and 4.
4. And Ms. S. Ward, Senior, Junior Advocate for respond number 5. Poster. Mr. Bora, Standing Council, ZDD ZMC has submitted that he is in the process of obtaining the necessary instructions to file the counter affidavit. And he will add the counter affidavit will also address regarding the situation in which these petitioners were allowed to occupy the flats among the 33, right?
33.
Flats. At,
My lord, I represented the beneficiary, original LOTs,
I know,
but
I know,
beneficiary has not been implemented.
I know. So you want to get yourself impleted. Nobody stops you. I am simply trying to find out how much they can stay. Up to what period? And what kind of right? Because they are temporary. Okay, and in the process of in what situation the petitioners were accommodated in the 33, temporarily accommodated, and the 33 flats at New Horizon Colony. First of he has submitted that he would need how much time?
3 weeks time.
3 weeks time to file the counter affidavit. Full stop. In view of the above submission made by Mr. Bora, standing counsel DDD, GMC, let notice be issued. The notice is made returnable on particular date after 3 weeks.
2nd May.
2nd May 2020, as so-and-so appeared, has accepted notice on behalf of the so-and-so. Issuance of formal list and suspense which to the said respondents. Extra copies within 2 working days from today. The interim order passed area shall continue till the next set of list.
54 same one.
Huh?
Item number 54.
No, 54.
Yes.
54.
54. I know the petitioner, petitioners,
Petition.
more than one, more than one.
27, my lord.
Okay.
Yeah.
Same date.
Deep law.
May I please it, your lordship? The matter pertains to cancellation of GST registration, your lordship.
What kind of all
Which show cause notice is at page 32,
Mhm.
lordship. The notice was uploaded on the portal. It was not served to the petitioner manual. And the petitioner did not even submit any reply. And there was no hearing also.
Mhm.
The order at page 33
Okay.
is a non-speaking
Will
order.
dispose of tomorrow, Mister? Same thing,
Lordship, similar order is
tomorrow,
On Epic of mine.
tomorrow.
Deep levels. Item number 15. Because he was specially instructed to appear in this case, my lord.
15,
15, my lord.
Ah.
15 is not there, my lord. He possibly fix it on Monday, my lord.
Monday.
This is a eviction matter yesterday, lordship. The state officer has passed a final eviction order, lordship, without giving me opportunity to file so cause, without taking evidence, lordship. And even the.
There shall not be any coercive action then. Till
yes,
Monday,
that-
till Monday.
ठीक है
Fix it on 7th, my lord. Entered.
7th, Monday.
Monday.
Monday?
No.
Mr. S.P. Roy, Learned Conservator petition is present. Mr. S.P. Roy, I heard Mr. S.P. Roy, Learned Conservator petitioner, and Mr. S. Bora, Learned Standing Counsel, GMDA, post of, for the respondents, post of the petitioner has assailed a speaking order dated 19/3/2025 passed by the asset officer. Asset officer, asset officer, GMDA. Under 6, section 6,
Section 4 notice was given.
4 notice,
Ah,
under section 6 order? No,
no, lordship.
this is not an order. I don't know what kind of order.
Page, lordship,
Ah,
20,
ah.
78, annexed 20.
Huh? Generally, section 4,
Yes,
followed by procedure under section 5,
5, Lord.
then order, final order under section 6,
No, 5.
5.
Five.
This is 5.
No, this is 4.
This is speaking order.
Yes, Lordship, first line. Whereas so-called notice under section is 4(1) of the
Okay.
PP Act.
Okay. Yes, pursuant to a notice, so-called notice issued under section 4, within bracket 1 of the Assam Public Premises Eviction of Unauthorized Occupants, comma, Act 1971. First of it is his contention that the procedure required under the Assam Public Services Premises Eviction of Unauthorized Occupants, bracket close, Act 1971, has not been followed in passing the speaking order dated 19/3/2025. So, Mr. Pora, Learned Counsel Pora, Learned Standing Counsel, GMD has submitted that has sought for posting of the case on 7/3. Full stop. Having regard to the projection made on behalf of the petitioner, comma, it is observed that the parties, there shall not be any coercive action on the basis of the impugned speaking order dated 19/3/2025 till Monday.
Right.
16. Item 16.
Matter relates to my suspension of my GST registration, annexure 2, page 21. Similar order your lordship has passed that I have annexed
No, these are cancellation.
cancellation, but notice was issued for cancellation. In the notice itself, they have suspended.
Yes, power is there,
Power.
section 21A.
So thereafter I am unable to operate my. lord.
That is up to you.
That's why I am.
We have to issue notice.
Otherwise,
This
your
cannot be disposed of. That was the final action.
lordship will give our representation that case.
So why you are challenging it?
Because they have.
What is section 21A or rule 21A?
29. Section 29. Power is there. Cancellation or suspension of registration.
Although no notice was issued for cancellation. ma'am.
Rule 21A. Sub rule 2. Sir, we have to examine whether he had reasons to believe or not. Sub rule 2. Whether a proper person has reasons to believe that the registration of a person is liable to be cancelled under section 29 or so and so, he may suspend the registration of such a person with effect from a date to be determined by him pending the completion of the proceeding. It is like suspension in service matter.
My lord.
We have to examine reasons to believe whether he is not.
Ultimately, what they are
matter-
getting while suspending I am unable to.
Sir, no. You are challenging a suspension order.
My lord, but
The same analogy with regard to suspension in other matters is,
my lord, but what is the precondition, my lord? Reason to believe.
we'll have to see the record, sir.
My lord, but my lord, in the impugned order,
Contemporaneously,
my lord, in
sir,
the impugned order,
if-
nothing is there, my lord.
no, if it is recorded in records contemporaneously maintained, then also it holds.
Without communicating.
We
with
have
my-
to issue notice, sir.
My lord, in that case, my lord.
Lordship, section 29.
See, we have
Or
to.
my lord, your lordship made instruction, and in that day, your lordship will see whether reason to believe.
Sir, you, on notice was 13/8/2024.
Lord, we are
You
NGO,
said
my-
about the matter.
and we are NGO, my lord, working. in
Huh?
the-
You bring the concept like that. What is that? It led to cancellation or what? It was not cancelled.
No order has been passed.
No order, but I am unable to proceed in the matter, my lord, because my portal, they have suspended it.
Lordship,
It is-
section-
What is this in the service jurisprudence? I have forgotten everything. That 3 months.
Suspension, my lord.
90 days. 90 days.
No,
Review,
what is the famous judgment?
Review of the
Ajay Chaudhary.
Ajay Chaudhary.
If you bring in a concept of Ajay Chaudhary in this case, then we'll decide.
My lord, moreover, my lord,
there is no reason, nothing in suspension, at least I am getting some pay or
Not,
lordship.
in service matter also not required.
But
Contemplated, see the word.
to your lordship,
See the word.
my lord is equating
Pending.
with service, my lord.
No,
Here,
no.
I am getting payment by pay your lordship, at least 50%. Here, my entire business has been installed, my.
No, we have to examine the reasons to believe or not. It is not that simple.
What's the power is under section 29?
I have
Has
seen.
to be exercised.
And this rule 21 also read, which rule 21.
reason
And
to
if you
believe in the-
see,
Notice itself, my lord, there is no reason has been assigned, my lord.
see rule 31. Section 30.
Section 13.
Let us see. That is another matter. Rule 21A, it is mentioned.
Please mention of
Ah.
the powers raised from section 29. Was amended in 2000.
I know in what basis, but we cannot interfere right now.
Where the proper.
I know what kind of, but if I go on
However, as your-
interfering in a motion state suspension is difficult. See the law settled.
But my lord, in the note, Soko's notice, there is no averment, my lord. It is just a, my lord, Soko's notice is like, my lord, order.
We can ask Mr. Kyle to produce material on what basis he had reasons to believe.
They have no reason, but they have reason, my lord. Apex court in Radhika Agrawal, that I will place, my lord.
What's it, may kindly please to peruse section 29. Section 29.
Yes.
Cancellation or suspension of registration. And the proper officer may either on his own motion or on application filed by the registered person or by his legal heirs. In case of death of such persons, cancel the registration in such manner and within such period as may be prescribed having so and so. Proceeding come to proviso also. It was amended in 2018, provided that during pendency of the proceeding relative to cancellation of registration filed by the registered person, the registration may be suspended for such period and in such manner as may be prescribed.
So prescribed is rule 21A.
Yes, it's there.
But here the terminology used by legislature is such period. Here, lordship, suspension, or there is no period, at least 3 months period. They, whatever, please note that your registration.
We cannot
stands-
read, sir, we cannot read into it, which the legislature has decided. We do not write the law.
What I am saying, my lord, legislature has written that for the certain period, but suspension has been made for indefinite period, my lord.
First,
not-
Mr. Goel, the fault lies on you on the first occasion,
My lord.
right? You are trying to shoot from an end with fault on your, all over your
That-
body,
That I admit,
right?
that I admit, my lord.
And thereafter, after suspension also, you are sitting over it. Is it not? Did you respond to it?
My lord, that
Did you respond to this?
portal, my lord, they are unable to operate because of the suspension.
Did you
I
respond?
have to respond by, in the portal, my lord. I am unable to operate. The-
Any inclination by, even
My
by
lord,
registered post,
system,
whatever? No.
if they suspended it, I am unable to operate my GST portal itself. My lord, it is like that, my lord. Everything is there, but nothing is there, my lord. They are saying to respond. but
Pending the
where-
completion of the proceeding,
My
in the rule it is there.
to your lord. They can do.
That is
My
there.
lord,
Heard, Mr. Eguel. Why don't you submit all the returns and everything?
6 months that will submit. If they open it, we will submit everything. my
Huh?
lord.
You respond, or
Well,
it is
yeah.
there, is it not there?
It is there.
That, please,
Page 21
that, what is it, section 29 or what?
regarding.
Rule,
23,
rule.
Rule 22 and 23.
They have
Yes,
given-
do you have the rules, sir?
Everything is now, my lord, online.
No, Mr. Please.
My lord.
Come to rule 22.
Four.
4. Proviso. If you file a reply, okay. Proviso, provided that when a person, instead of replying to the notice, served under sub-rule 1 for contravention of the provisions of so-and-so, that is regarding 6 months, furnishes all the pending returns and makes the payment of the tax along with applicable interest, late fee, the proper officer shall drop the proceeding. Pass an order. Why don't you do that?
He has not taken any step.
Nothing. Sitting over that and coming to before the court challenging it.
My lord, I am instructed, my lord, because of suspension of portal, they are unable to reply. This is the instruction.
The other option you don't want to avail.
That is true, my lord.
Hmm.
Physically,
If you give all the pending dues, he will drop, he will remove.
that will. Absolutely.
So it is up to you. Shall I observe? Pending of the writ
At
petition.
this stage, your lordship may issue notice. In the meantime, I will take.
The
it.
pendency of the writ petition shall not be a bar.
My lord,
I think that will
my lord, that,
cleanse the issue,
my lord, that will.
right?
Right.
Heard. Mr. Goel, learned. Counsel for the petitioner. And Mr. S.C. Kel, standing counsel. Petitioners, huh? Standing counsel, CGST for all the respondents. Post up. The petitioner has approached this court. Assailing. So a so-called notice dated 13/8/2024. And you also know the jurisdiction to set aside a so-called notice.
My lord, but in certain circumstances that.
This appears to be clear. We are not setting aside the so-called notice. We are setting aside the cancellation order.
Yes,
My lord.
If you remember correctly.
But this order is, my lord.
Issue notice
suspension order.
whereby the petitioner's registration under the GST, Central Goods and Services Tax Act 2017 has been suspended with effect from 13/8/2024. Issue notice returnable on so and so.
7/5.
As Mr. Kyle has appeared and accepted notice on behalf of all the respondents, from issuing the formal notice to the respondents and dispense with the learned counsel for the petition shall serve furnish requisite number of extra copies of the petition along with annexed to Mr. Kyle on so and so within 2 working days from today, post of pendency having regard to the provisions contained in section
29.
29 and
22.
rule 23 or 22.
22/4.
22. 4. 22. It is observed that pendency of the writ petition shall not be a bar for the petitioner to proceed to approach the competent authority as per the proviso to sub-rule 4 of Rule 22 of the CGST rules, read with section 29
20.
of the CGST.
Item number 17. May I please, your lordship? Petitioner is a resident of ward number 6 of Ilaspur, Gaon Panchayat, lordship.
Now what to do now? Tell me.
Lordship, may I dispose.
My hands are tied.
May I dispose
Tell me a way out. Yes, can be done.
of the representation, lordship.
Representation can be disposed of or what?
May we
My lord,
You do
his
whatever.
representation was, my
If
lord.
it is genuine mistake, you can correct. If it is not genuine mistake,
Otherwise, my lord, his representation first was 17/1, then second one 23/1. Now he has waited till the notification. is in.
No, no. Lordship, petitioner has filed,
April, my lord.
petitioner has filed the petition in next week, lordship.
You have waited since January. If you, have- if it it is
Earlier petition,
correct.
no, Lordship, earlier petition was also filed the petition before this honorable court, Lordship. But due, as the petition has not annexed some notification, Lordship, so this honorable court granted the petitioner to withdraw this petition with the liberty, Lordship, to file a fresh, Lordship.
Right.
Therefore, Lordship, in the meantime, Lordship, the election commission has issued a notification, Lordship, for activation of the electoral rolls, Lordship. So again, Lordship.
No,
petitioner
that
has a
is-
presentation, Lordship,
no,
23, 23-1, Lordship.
Mr. Council, it was on 23rd of January 2025,
Yes, Lordship.
right? We are into February. We are disposing of writ petitions
Yes, Lordship.
regarding this kind of,
Yes, Lordship.
on the basis of the page 36 circular,
Yes, yes, Lordship.
right?
Yes.
You should have come at the proper time.
Lordship, here petitioner filed this petition, Lordship, before the notification
I
present.
don't know
Yes,
if
Lordship.
your representation is
filed
not
petition.
disposed of. Now the time is over,
He
apparently.
may give direction, Lordship. He is not contesting the election, Lordship. Just only his house is deleted from this ward,
Yes,
Lordship.
Mr.
You are true, Lordship. Only his house.
You
And-
dispose of
Yes, Lordship.
the writ petition. Heard, Mr. NH
Lost card.
Law School, Learned Council for the petition. Mr. S. Doctor. Learned Standing Council Panchayat and Rural Development Department for response number
1, 3,
1,
4.
3 and 4. Okay. This electoral roll, right, will correct.
Actually, it's.
That man is not
Election-
made a party.
Election commission.
Election, district election.
No,
commission.
no, page 38.
Yes. Election officers.
Election officer.
He is not a party.
Yes, Lordship.
Where?
No, not a party.
Unfortunately, it is missing, Lordship. I may not amend this perspective.
It is up to you.
Yeah.
On the prayer of
Yes.
Mr. N.S. Loskal, Ramin Council for the petition, list the case on Wednesday.
Yes.
I cannot give a direction.
We can withdraw and file replace.
It
because
is
it's
up to
first
him.
time. Otherwise, after that, he again have to rectify the post title. Thereafter,
Yes.
No, I may allow withdraw, Lordship.
Okay,
Yeah,
Mr.
but-
N.H. Loskal, Ramin Council for the petition has submitted that the petition may be allowed to withdraw a petition with the liberty to file a press post.
Yes.
Mr. S. Doctor, Learned Standing Council, Panchayat and Rural Development Department, for response number 1,
1, 2, and 4.
1, 2,
1,
and
3, and
4.
4.
1,
3, and 4.
3 and 4, and Miss A.B. Castro, Land Council representing Mr. R. Dubey, Land Standing Council, Assam State Election Commission for the response number 2 are present and they have no objection to the prayer made by the Land Council for the petition. First, the main view of the above submission made by Mr. Loskal, Land Council for the petition, the petition stands dismissed on withdrawal, come out with the liberty to file a press.
I love you.
Item number 18.
May I please, your Lordship. Now, Lordship, the petitioners are husband and wife, Lordship. They have
Hmm.
bought a piece of land, Lordship.
Hmm.
Great difficulty, Lordship. Now, the land they had bought had been a requisition, Lordship,
Your Pata lands.
Pata land, Lordship.
Yes, so it's notice
Lordship.
heard. Mr. M. Bhagavati. Learned Council for the petitioners. Ms. G. Hazarika. Learned Standing Council Revenue Department for response number 1.
I for 4 and 5.
Who is for 2? S. Bora. Miss J. Rajkumari. Learned Council representing Mr. S. Bora, Learned Standing Council ZDD for response number 2 and 3 or 3? 3, not 3. Mr. N. Goswami, Junior Government Advocate Assam for the respondent 4 and 5. Full stop. The petitioners have stated that they are joint owners of a plot of land measuring 15 lessers, or they are owners of land measuring 15 lessers each, covered by diag number 408 and Patna number 212, situated village Sodilapur, Mauja, Jalukbari, Kamrup Metro, District Kamrup Metro. Also, by an order passed under Section 3 of the Assam Land within bracket Requisition and Acquisition bracket close Act 1964, passed in LA case number 14/2022. The respondent number 4 has had requisitioned the subject plots, for the purpose of construction of sludge drying bed, page 23, near water treatment plant within bracket WTP of South Guwahati Waste Water Supply Project at village Sodilapur. Post op. As neither any requisition payment was made, nor any acquisition process has been initiated after the order dated
30/12/2022.
order dated 30/12/2022. The petitioners are before this court. First of the petitioners are seeking directions to the respondent authorities either to release the requisition subject plots, or in the event the subject plots are required on permanent basis, to acquire the subject plots and provide adequate compensation to the petitioners as per the provisions of the Assam right to fair, as per the provisions of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2023. Issue notice for returnable in 4 weeks as so and so has appeared. Accepted notice on behalf of so and so, issuance of formal notice dispensed with extra copies within 2 working days. The petitioner shall take steps for service of notice upon the respondent number 3 by registered pursuit AD within 2 working days from today. Yes.
19.
May I please the lordship? Lordship, the matter pertains to the blanket fees of my bank account, of my salary bank account, lordship, in connection with 2 cyber complaints from 7/3/25, lordship. Lordship, may kindly come to page 30, lordship. This is the email, lordship, that I
Page?
received. Page 30, lordship. Annexure 6. May I read, lordship?
Well, issue notice at this stage.
Lordship. Very well, lordship.
Heard, Mr.
S. Mitra, lordship.
S. Mitra, learned counsel for the petitioner. Yes, madam, you appear for whom? 9 and 10. Okay. Any standing else is State Bank of India?
No, Lordship.
Okay. The petition is before this court. Agreed by David Freeze instruction placed by the respondent number
Lordship, 6 and 8.
6,
Lordship, 6 and 8.
6 and 8. In respect of the petitioner's bank account number 0 108 21 75 461 maintained at which branch?
SBI dispute, Lordship.
Maintained
point number
at
4.
the dispute branch of State Bank of India. On
The Lordship, the debit transaction has been freezed from 7 March 25.
7/3/2023. Full stop. The petitioner has contended that there appears to be a disputed transaction dated 20/12/2024 amounting to rupees 49,000. And the concerned bank account is one where the petitioner's salary gets deposited.
Lordship.
First, monthly salary.
Lordship.
Okay. Issue notice returnable on so and so date
7/5.
as MS Borua. That is Central Government Council, no? Accordingly, he was Central Government Council. Has appeared and accepted notice on behalf of the respondent number 9 and 10. The issuance of the foreign so and so dispense with the petitioner shall take steps for service of notice among the respondent number 1 to 8 by registered post with AD within 2 working days from today.
May I pray for observation, Lordship? Lordship, since the salary will be created in this account, so I may be allowed to withdraw that part of the salary, Lordship. Because every month the salary is going to get credited.
Let them, you maintain another account.
Lordship, I have already preferred representation, Lordship, but that is going to take some time.
Without
Lordship, I'm a
getting
cancer patient,
instruction
Lordship.
from the other side response, it is difficult.
Lordship,
Possible.
whatever is there as on date, that may be.
David Freeze, it should have been, proper instruction should have been lenient.
Lordship.
There, it is not there.
Lordship, the quantum of amount has to be there. They
At
have
least
just
some
fixed it.
instruction should come. You change the salary account.
Lordship, may I kindly fix a date, Lordship?
I have fixed already.
Obliged, Lordship. Obliged, Lordship.
20. Item 20.
Mutation,
Lordship, not mutation, it is a
demarcation.
Just demarcation has not been done.
Yes. Heard the petitioner in person. Ms. G. Hazarika, learned standing council revenue and disaster management department for respondent number 1. Mr. N. Goswami, learned junior government Bukit Assam for respondent number 2 and 3. Full stop. The case of the petitioner is that he purchased a plot of land measuring 1 bigha, 2 kathas, 2 lessas, covered by Dag number 20 and KP Patra number 381, situate at village Rongia town, Moja Pandubi, Rongia Revenue Circle, District Kamrup, Metro, by from the erstwhile landowner by way of a registered sale deed after obtaining necessary approval stroke permission from the District Commissioner Kamrup on 6/5/2023. Registered sale deed is 3/6/2023. Subject one. Full stop. Mutation is also done.
Yes, Lordship.
Okay. After purchase, comma, the subject land has also been mutated in favor of the petitioner. On, any idea?
Lordship, it is,
Full stop.
uh,
And the petitioner is paying the land revenue. Land revenue, you are paying land revenue?
Yes, Lord.
Since then, full stop. Para. The petitioner has stated that on 27/6/2023, the petitioner submitted an application before the respondent number 3 seeking demarcation of the subject land. Full stop. As no process of demarcation has been initiated. Demarcation of a subject land has been initiated by the respondent number 3, by the respondent authorities, more particularly, the respondent number 3. The petitioner is before this court. Full stop. Line. After so and so, after some submission of the application for demarcation of a subject plot on 27/6/2023, the respondent number 3 had issued notices to the concerned other interested persons on 20/11/2023. Full stop. As after issuance of the notice on 20/11/2024, the respondent authorities, more particularly the respondent number 3, has not proceeded further with the process of demarcation. The petitioner is before this court. Full stop. Petitioner has stated that a number of dates were fixed for demarcation, but for one reason or the other, the respondent number 3 did not carry out the demarcation process, right?
yes, Lord.
Okay. Yes, Mr.
Yes, notice was served to the co-patterer. They may not be lots of turned up.
So-
Your Honor, it is not to the co-pottader. I am the sole pottader. It is notice served to the adjacent.
Right. That is why I said stakeholders.
Lots.
Yes.
It is nearby nearby landowners. Separate decks, separate.
Would you like to take instruction or?
No, I'll take, sir.
Huh?
I'll take it, sir.
Okay. Then let them take instruction on it.
Lordship, probably if a direction gives from
Oh,
the
yeah,
honorable
yeah.
court, then
Yeah.
they will be.
Mr. Goswami, learned junior government advocate, Assam, has submitted that he'll obtain instruction as to why the demarcation process initiated by the notice dated so and so has not yet been brought to its logical conclusion. First off, in order to, as sought for by Mr. Goswami, list the case on.
Second on
Before, immediately after Bihu,
29.
put it 23rd,
Lots.
23rd.
Extra. copy.
The petitioner in person shall furnish a copy, an extra copy of the writ petition, along with an extra to Mr. N. Goswami. You have with you available?
I will leave it.
Okay, during the course of the day. To enable Mr. Goswami to take necessary steps from his end.
Item number 21.
Next one, same thing,
Same, Lordship.
on me, petition in person. देखिए बहुत 2 बीघा 4 kathas. Dag number 128.
120.
KP Patta number 27. ভিলেজ দক্ষিণ সিটারা, মৌজা পান্ডুরি, রঙিয়া রেভিনিউ সার্কেল, ডিস্ট্রিক্ট কামরূপ. After a family settlement and a gift deed dated 4/2/2010 executed by the father of the petition, right?
Yes, Lordship.
In favor of the petition. After the gift deed, comma, the petitioner applied for granting a separate patta for 1 bigha 3 katha 13 lesser or what?
Yes, Lordship. That
Huh?
time I.
Out of.
Out.
Okay. 1 bigha 3 katha 13 lesser out of 2 bighas 4 kathas covered by diagram soil. After the gift deed, the petitioner applied for granting a separate patta for the subject land, and the respondent authorities issued a separate patta in respect of the subject land with new DAG number 393 and patta number 148 via an order dated 26/8/2022. Poster. Then demarcation, right? Demarcation notice 19/3/2024. Several dates, huh? Several dates, fixed several dates, but did not carry out the demarcation process. Same. Same date.
May I make the correction, Lordship?
Yes.
It was given 2 bigha 4 katha, but I have accepted 2 bigha. So
Okay.
I have mentioned here 2
Uh-huh.
bigha, Lordship.
You have been given 2
although
bighas.
It was 2 bigha. Lordship.
Okay. So,
Wherever-
bottom part of 1 bigha to cut it.
Lordship,
Out of the land gifted to the petitioner, the petitioner applied for separate patta.
separate patta 1 bigha.
3 katha, 13 less.
But originally, my father gave me 2 bigha 4 lesser, 4 katha. But I have asked for mutation for 2 bigha, Lordship.
Right.
So in my name, it
So,
is 2 bigha, Lordship.
Initially gifted 2 bigha 4 katha,
4 katha.
and out of that you asked for separate patta for 1
No,
bigha.
no, Lordship. A mutation for 2 bigha, Lordship.
Huh?
And separate patta for 1 bigha 3 katha 13 lesser, Lordship.
Okay. Okay, লিখি দিব এটা কাম কৰিব। An extra part to develop the petition in this petition has projected on the paragraph 2, 3 and 4. লিখি দিব। ঠিক আছে? And 5 লিখি দিব। 2, 3, 4 and 5. তাৰপিছত বাইকিং লিখি দিব। Notice.
Deeply.
Same extra copy, same date.
I will. Same date, Lordship. Deeply obliged.
Item number 22.
Notice নাই কৰা।
My lord, this is in respect to release of compensation, my lord. Lordship,
By, it is written by whom?
it is written by municipal.
Bojai Municipal Board.
Municipal
Thing.
corporation. Thing.
Okay. Heard, Mr. J. Roy. Senior counsel is stated by Mr. Chakraborty, C. Chakraborty. Learned counsel for the petitioners. Mr. N. Goswami, learned junior government advocate Assam, for the respond number.
1, 2, 3, and 4.
You were there for Dhing also.
I can appear for 1 and 4 lordships. See, I'm in notice to go lordship.
Okay, 1 and 4. 1, 4.
Plus
And 6 also?
6 also lordship.
1, 4, and 6. Mr. B. Chaudhary, learned standing counsel, Public Works Department, for respond number 7. Okay. The petitioners, 17 number, have stated that they were allotted vetis at Dhing Bajar by the respondent Dhing Municipal Board. And after being so allotted, the petitioners carried out their business from those vetis. First off, by constructing shop rooms and investing with their own investment, and by paying municipality taxes. First off, in the year 2021, the Public Works Department, after carrying out a survey at the place where from the petitioners are running their business from the vetis, the petitioners were informed that there will be construction and expansion of the PWD road under the Assam Mala project. And in that connection, a portion of the petitioners' vetis would be dismantled. Full stop. Thereafter, after issuance of notices on 7/5/2024 by the respondent number 4 to the petitioners, by issuance of notices, dated 7/5/2024, the respondent number 4 asked the petitioners to demolish the marked area of their respective vetis, and the petitioners duly carried out the directions. Post up. The petitioners have come to learn that an amount of rupees
Page 77, madam.
total amount.
24 lakhs and 25 lakhs, madam.
Okay. Sums of rupees 24,64,025 and 25,06,183 have been deposited by the Public Works Department with the Dhing Municipal Board in the meantime as compensation towards damages to be paid to the petitioners, as the said amount has not, the said amounts have not yet been disbursed to the petitioners, despite submission of representation from the petitioners by the authorities in the respondent Dhing Municipal Board. The petitioners are before this court by the instant writ petition, seeking inter alia direction to the respondent authorities, more particularly the authorities in the Dhing Municipal Board, to release the compensation amount. Post of issue notice returnable on so and so, as Mr. So-and-so has appeared and accepted, as so-and-so has appeared and accepted, issuance of formal notice and dispensed extra copies within 2 working days. The petitioner petitioner shall take steps for service of notice. Upon the respondent number 3, 4, you are, and 6. 6,
2, 3,
huh?
and 6.
2,
3.
3, and 2, 3 only. 5, 5. 2, 3, 5 by registered post with AD. Post. In view of the projection made by the petitioners, it is observed that the pendency of the petition shall not be a bar for the respondent municipal board authorities to disburse the compensation amounts if the petitions are found entitled.
7/5.
Public.
Item number 23.
Regarding the GST cancellation, GST assessment.
Where is your notice?
We don't notice, without even so goes notice.
Huh?
My lord. Page
It
27.
cannot be.
Page 27, madam. Level.
And then,
Page 27.
where is this sending out the GST? Page 23. Huh?
We have not been served with this copy.
Who has been served? Enquiry Dr. B.N. Gogoi. He may be served. Find out.
24. Item 24.
May please, your lordship.
Hmm.
Lord, in this case, my lord, the 30 numbers of petitioners are before your lordships, my lord.
We have to issue notice at this stage.
Lordship. And only, my lord, one observation from your lordship that the
Submission of facts. I have instructions, my lords. Number of petitioners, except a few, have already approached the arbitration. If they have ever arbitration, what's the purpose of filing a writ, my lords? And thereafter, my lords, we are not touching the lands. 17 out of there are 25 petitions, my lords. 7, we are not even touching the land, my lords. These instructions are very clear. I have even parawise.
Let him file the affidavit then, my lords.
No, first he has to clarify this thing.
Yes, we have not suppressed, my lord, that we have approached the arbitrator, not for a minute. We have annexed the letter of the arbitrator asking for parawise comments.
And we are not touching the villages also.
You give the clear picture in your, you can issue notice.
Yes. That's all we are saying.
Give the clear picture, then everything will be crystal clear.
Yes.
If they have approached other authorities and their lands are not acquired, and their lands are not falling in the right of way, then on the other, they might be the encroachers. If they still claim, if they don't have the lands in the right of way, because otherwise, if this kind of acquisition is carried out, proper survey is carried out.
Survey has been done.
Will issue notice.
Yes, my lord. Yes. The pendency may not bar.
File your reply then immediately.
My lord.
File your reply
Yes,
within 4
yes,
weeks. You have the copy.
Yes, I have a copy.
Okay, I did not again prepare हो जाए. Heard, Mr. A. Ganguly, learned counsel for the petitioners to virtual mode. And
I R4, my lord. That's the number 1.
Mr. Z. Pegu, Central Government Council for respondent number 1. P.R. Mohanto. Standing Council. Or Revenue Department for respondent number 2. Who is for 3? NHA.
Normally he appears.
Okay. Okay, we'll ask them to serve the copy.
Yes,
Mr.
sir.
D. Goyal, Standing Council. NHIDCL for the respondent number 4. Mr. N. Goswami, Junior Government Book Assam for the respondent number 5, 6, and 7. Full stop. The case of the petitions is that while carrying out the extension of National Highway number 515 in the stretch of land from KM 0 plus 100 to KM 27 plus 701 within bracket PKG-1 in the district of Nemaji, the petitioners for sales of land came within the purview of the acquisition process initiated by the respondent authorities under the provisions of the National Highway Act 1956 as raising grievances with regard to compensation, the petitioners have approached this court by the instant petition. Mr. T. Gogoi, Mr. Gogoi, the Standing Council, NHIDCL, appearing for a respondent 4, has submitted that as per the instruction received by him, preliminary instructions, the petitioner's parcels of land are not within the right of way and their parcels of land are not acquired in the process. First of, he has further submitted that few of the petitioners have also approached the arbitrator in the meantime. Okay, the matter would require deliberation, further consideration, issue notice returnable on so-and-so.
7-5.
As so-and-so has appeared, accepted notice, extra copy to working this green DDO. The Learned Council for the petitioner serve a copy along with the annexer to Mr. C. Borua, Learned Standing Council, NH National Highway Authority of India, for service of notice upon the respondent number 3 within 2 working days from today.
My lord, there is a connected writ petition, my lord, WPC number 1153.
Let it be returned thereafter we take.
Lord,
Alright.
tablet.
Supplementary list, item number 55.
For that one.
My lord.
Ah.
Regulation 23, my lord, what shall we see? Regulation 23.
Regulation 23.
23, my lord.
22, 23, 24.
My lord. So, well, under that.
So, prayer, let us see your prayer. To demarcate the plot of land belonging to a petitioner's family measuring 3 quarters 16 lasses. Prayer to restore possession of the petitioner's family, right,
Right.
over the land measuring 3 quarters. Now come to your statement, perhaps. Paragraph 7. Every right to know the boundaries, right? Assam Land and Revenue Regulation. And your
Paragraph 4, my lord.
paragraph 4.
Till December, my lord, they were in possession, my lord.
No, where did you say? Let us see. Hmm. What are your DUG numbers?
Doug number 635, my lord.
What did you say in paragraph 5?
Yes, my lord. Both, my lord, I am. in the
And what
DD
is section 22? How much they can do? How much they can do?
Hmm.
23.
23, my lord.
Hmm. Proceed if a dispute is between proprietors of different assets, settlement officers shall decide it on the basis of actual position. You have lost position out of entire, some part you have lost position,
My lord.
right? So your prayer, in prayer number 1,
Yes.
you are claiming
Demarcation.
which cannot be done because of your own admission. Because of your own admission in paragraph 5. So this prayer for demarcation of the entire land, that is not permitted. That is not possible. And I cannot give direction. This court, knowing fully well that petitioner has lost possession of a part of 3 bighas so of a part, I don't know what part. So I cannot give direction for 3 bighas entire for demarcation. What cannot be done by them? I cannot. This is wrong.
Well, under section 20, well, regulation 23.
23, if the dispute, they can decide only on the basis of actual possession, which you have lost. A part of it, you have lost the position, right? Suppose 3 bighas, 16 lessons, right? What, 3 bighas?
3 katha and
3 katha,
16 lessa, my lord.
16 lessons. Suppose you have lost position of 16 lessons because of the unauthorized, whatever, by the private person.
Right.
Now you have possession over, say, for example, 3 kathas.
Yes.
And your prayer is this 3 kathas, 16 lessons. You want a direction.
The my actual land is 3 katha 16 lessa, my lord.
Right. No, that is what I have said. Prayer 2 is related to prayer 1. And this, what cannot be done by them, I, with the issuance of a mandamus, should not do it. No, absolutely not. No, I do not want to put a litigation unnecessarily. It is a different thing. 3 kathas, 16 lessons. I go by their prayer. Paragraph 5, clear, you have lost position. He has erected a boundary wall. All these things. Beside the boundary wall, you make an application. If they don't process, it is a different thing. But we are not going into what cannot be done directly, cannot be done indirectly. I am putting it, you file appeal. I am putting it.
Page 22.
No,
Page
I am
22.
putting it. I am making it clear.
Page 22, my lord, I have file application before the competent authority.
No,
It has
what
not-
is the prayer? We go by the prayer. We do not direct. Admission in view of clear admission. Occupied a portion of DUG number C635, erecting a boundary wall on it.
That is true.
It is true.
That is true. They have erected the boundary wall.
They cannot now,
Parcel
these
of-
authorities, circle officer cannot go and demark that because you have lost possession of a part of it. 3 out of 3 bighas, 6, maybe it is 1 lesser, 2 lesser. And second prayer is related to first prayer, sir. Hard, Mr. Sorry.
In that case, Manoj, I will withdraw this petition with the liberty.
You make proper demarcation application. Then thereafter, they don't do it, you come. But what should be done through the civil court cannot be done through the writ court. It should be done by the civil court. You know the prayer too. You have admission, you have, at least you are fair to the court. To that extent, I can say, prayer may be wrong, but statements are fairly made. To that extent, the petitioners are fair. But the prayer which relief, which you have sought, that is not maintainable in a writ petition because of rule section 23. Because they can't do it.
Yes.
They can't do it.
Alternative-
These authorities can't do it.
I will have
The first
another-
prayer. Have you understood? Have you understood what I am saying?
Yes.
Because of section 23 of the Assam Land and Revenue Regulation, and because of your own ambition, I know they cannot demarcate 3 kathas, 16 lessas.
But Manoj, the petitioners are, Manoj,
Right,
not
you make
aware
proper application.
which
It is
person has,
already there is a boundary wall. So they cannot cross over.
boundary wall they have made of their own money.
You have said fairly, truly you have said. That makes the position difficult. It is up to you, otherwise I am not. For these prayers, with these prayers, I am not will not proceed further.
I will do it.
Huh?
With the liberty.
Liberty, yes. You make proper application before them, that demarcate all the boundaries, give me the areas, this much is less, 15 lesser, 16 lesser is less, then you go for civil suit for restoration.
Then only I can go, Manoj.
But the application is not, the prayer here is not proper. Which they cannot do, I will not permit. By my mandamus. Am I sure? Clear? Already a boundary wall. So I simply say, you make a proper application, it is up to you. Heard Mr. I. Soikia, Landed Council for the petitioner. Petitioners, Mr. And yes, anything you do.
There are 5 laws. We don't have to wait for this process. Boundary wall is already there now.
Prayer to is clearly a case for a civil suit. And this is interlinked with prayer 1. G. Hazarika, Standing Council Revenue 1.
I got 12 feet.
And Goswami 2 and 3. After a hearing for Land Council for the parties at some length, Mr. Soikel and Council for the petitioners has submitted that the petitioners would withdraw the writ petition, in order to seek a relief before the appropriate forum, stroke court, as permissible under the law, in view of the above submission made by Mr. Soikia, Learned Counsel for the petitioners. The writ petition is allowed to be withdrawn with the liberty as prayed for. Make application beyond the boundary wall, then come.
Item number 56.
Six. Yes.
May I please your lordship? My lord, by this requisition, I have challenged the validity of the so-called notice as well as the assessment order. And apart from these two, I have also challenged the validity of the notification, which has been issued on 31/3/2023 by the central government, my lord. My lord, first of all, prior to coming to the assessment order,
This notification is under consideration of the Honorable Supreme Court perhaps, is it not?
No, this matter is
Nine
not.
and 56.
Both. Hmm.
Here, subject to what my learned senior says, here the order was original passed, thereafter they preferred appeal. And regarding challenge to the notification was never taken before the authorities. And this is the order is appealable and their appeal was dismissed.
Appeal was dismissed.
Yes, it was dismissed on the ground that pre-deposit was not.
Hmm? Oh, pre-deposit.
Now they are.
Then situation is different.
My
If
lord,
you- because if the pre-deposit is not made, then
appeal is
that
not-
order does
No,
not, is
that-
not merged.
That order,
That under that order, under the carpet. Now your original assessment order is under the carpet of the dismissal of the appeal in limine.
now, my lord, your lordship
If
is
you-
one thing.
If
First-
you challenge the order passed in appeal on different grounds, it is a different issue. We'll issue notice at this stage then.
No, my lord, one thing. Your lordship will come to the notification that your lordship will. find.
Notification, we are not touching because now it is Supreme Court who is,
No, my lord, since this notice is also.
yes, sir.
Nine and 56.
Yes, sir.
And our High Court lordship passed order that only 56 was interfered.
Yes,
This is 9.
this is
not
9,
interfered. And
and our honorable High Court has interfered with
only 56.
56, and for that judgment is with me, my lord.
Hmm.
Your lordship may go. to
9
the-
is not interfered with, but
Yes.
9 is still validity and propriety of notification number 9,
Nine, my lord. That was, my
dated
lord,
31/3/2023,
my lord,
right?
for that
Is
was-
under consideration. Now everything is legality, validity, propriety, all are before Supreme Court.
RO before the honorable.
But your appeal, where is the appellate order?
Appellate order, your lordship will.
Let us see.
My lord, prior to coming to the appellate order, may I come to the judgment of this honorable court, my lord? Passed in relation to a different notification 56, my lord.
This judgment is also under consideration.
That is.
Naturally, it may be. under
But your
consideration.
appeal, let us see your proceeding first.
Page 67.
Yes.
Discussion and response.
Page 58. my
I note from APL.
50.
Amount paid, deposit has been indicated as zero. From the various sections, so into subsections, so it's allowed. Minus. If you challenge this appeal on different ground, is a different thing.
My lord, though I have no challenge the appeal, my lord. If the
This
notice.
appellate order, you've challenged on a different ground,
No.
is different thing.
My-
Did you take this ground?
In this writ petition, they have not challenged the appellate order.
Appellate order, I have no challenge. What I have challenged, my lord, what I am saying that this order, if the notice is any assessment order,
Sir,
Is
we
it
can
any-
only issue notice to consider further.
my lord, only one thing. Your lordship-
Because your assessment order came under the umbrella of the appellate order. And because of the dismissal of this appeal with this kind of order, I think Honorable Supreme Court has said the original order did not merge with the appellate order. So it lied under it. If we go by the interpretation of the Supreme Court, then this original assessment order lied under the appellate order, because appellate order was not on merit, on
Order.
technical ground.
Yes,
If you challenge that, yes, that say for example, at least the petitioner should have been given the opportunity to deposit the pre-deposit amount, yes, that can be considered, but not now section 9, no.
now, my lord, apart. from
Then
the-
I'll
Definitely, my lord, your lordship may pass the necessary orders, but even though if your lordship will come to the judgment of this honorable court,
what do you have challenged here?
challenge, I have challenged even the notification, my lord. Notification that your lordship will find at page 70. Apart from assessment order, I have also challenged the notification which has been issued, my lord, by the central government.
That is a problem, sir, to my limited understanding. This assessment order dated 2012-2023.
Yes,
It cannot be set aside without setting aside the appellate order. I think Mr. Bhatti is
my
a
lord.
very seasoned.
My lord, it has merged in the final.
No, that is the problem. To my limited understanding.
I agree, my lord, with this proposition of this.
So when the
But what
when
I'm going
there
to
is an
submit, my-
appellate order, I'm
Yes.
just trying to understand. There is an original order, right? And above that, there is an appellate order.
Appellate order, my lord, that appellate order was passed only on my appeal was rejected only on technical ground. First of all, my lord. Secondly, that I have stated in my petition, my lord. Secondly, my lord, your lordship will see. So far the notification is concerned, central government notification. The appellate authority has no judicial
That-
role to touch it.
That
To touch it. And now, if originally, if that cannot be touched by the appellate authority, my lord, in that case, my petition is maintainable. And for that one, I am taking to your lordship at page 70.
a read petition is maintainable. We'll decide whether it is to be entertained or not. We'll issue
Yes.
notice at this stage.
My,
I'm not saying that it is not maintainable.
my lord, as so far the stay is concerned, otherwise, I would,
Okay, you say I'll observe.
now, only one thing, my lord, I am going to show.
You make submission on interim prayer, Radha Khanwilkar, Glaxo. We'll observe.
Definitely, your lordship may observe.
No, it is law. I'll recourse to law to my limited understanding, what I have understood.
My lord, the objection.
And there is no challenge to the appellate order, so
No challenge, my lord. In other words, I have no challenge. But so far the statements are made. In that one, I have said in many words that this appellate order is was passed only on technique, and my appeal was rejected only on technique.
right, but it is still an appellate order. Under the, now your assessment order, final order, order in original, is now under the carpet of the appellate order.
Yes, ma'am.
Without the appellate order being removed or set aside, we cannot go into the order in original. Problem lies there. And on technical ground, on the ground of limitation or on the ground of non-deposit of the pre-deposit amount, if the appellate authority dismisses the appeal, that order, according to Honorable Supreme Court, does not merge with the order in original. I don't know for what reason they have observed. After an election. Oh, yeah, I put one. This is the situation. There is no whisper in the prayer.
Nay, in this, I have.
No
not
whisper
made-
in the prayer.
They have not made, and accordingly, I will amend the petition, my lord. In the meantime, your lordship may issue the notice of motion, and I would make the prayer.
This is up to you, amending
Yeah.
all this. Had it been the appellate order been challenged, we could have the occasion to concern with it. Just because non-deposit of the pre-deposit amount, the appellant should not
Be penalized.
be non-suited, maybe. Because it is a curable thing. Could have been a curable thing, perhaps. But that order is not challenged. What we can do? It is up to you. And Mr. Cal may file objection to the amending application. Everything will be topsy-turvy. Heard Mr. O.P. Bhatti, Learned Counsel for the petitioner. And Mr. S.C. Kyle, Learned Standing Counsel, CGST. For all the respondents? Okay. The petitioner
Yes.
has approached this court. And by instituting a writ petition under Article 226 of the Constitution of India to assail an order in original dated 20/12/2023 passed under Section 673 of the Central Goods and Services Tax Act 2017. And a notification dated 09/2023 dash Central Tax dated 31/3/2023 issued by the central government under Section 168A of the CGST 2017. Full stop. The ground of challenge to the notification number so and so is that there was no prior approval of the GST Council.
Recommendation.
Huh?
Recommendation of the. Recommendation.
Recommendation of the.
Oh, there is no recommendation of the GST Council.
And apart-
Council. And the issue has been covered by a decision of the coordinate bench of this court.
My lord, one ground is also there. Four major clause.
Huh?
Four major clause, because
Force measure.
force major clause, man.
It is there already.
Yeah.
It is there.
Yes.
Is it not?
Force it
Yes.
is there, but with regard to notification 56 only. There is a GST.
Oh, it is not there. Oh, 09 is not there. No, I get confused with 56 and 9 sometimes. So 09 has not been dealt. Oh, then it is there before the Supreme Court.
Yes. At Telangana High Court.
Against the Telangana High Court judgment, special leave to appeal.
Yes.
They will consider legality and validity. Now they are insisting on the
Naturally,
matter.
my lord. But till it is decided by the Honorable Supreme Court, I may be left without any remedy, my lord. So far the stay is concerned.
Mr. Bhatti, I had indicated, now I'll observe now.
Yeah.
If you press for the interim order, press it.
No, my lord, I will file the amended petition later on. I
Up
will
to you.
place it. I may be given the opportunity. to-
Sure. I'll observe the
For-
prayer for interim relief is kept open for
Ah.
consideration.
All right.
Mr. Kyle as planning of the CGST has submitted that against the order in original, the petitioner had preferred an appeal before the first appellate authority, that is the Commissioner Appeals, and the appellate authority has passed an order in appeal on 31/1/2025, dismissing the appeal on the ground that the petitioner did not deposit the requisite pre-deposit amount. And there was no application for waiver. And there was,
Application for waiver I filed.
okay, okay.
That
Full
is there.
stop.
That is there,
Mr. Gyal has further pointed out that the order in appeal dated 31/3/2025 has not been put to challenge in this petition. The matter would require further consideration, issue notice returnable on so-and-so, as so-and-so has appeared accepted notice on behalf of all the respondents, issuance of formal notice to the said respondent stands dispensed with extra copies within 2 working days, and had the learned counsel for the parties on the interim period, to stop the having had the learned counsel for the parties on the interim period, the prayer for interim release is kept open for consideration on the returnable date.
Much of My lord, I am going to give you the troubles.
Huh?
I am going to give you the troubles, my lord. So for item number 56 assist, this I conducted, my lord. Let me kindly be allowed to be withdrawn with liberty to file a case.
Okay. Order signed to you.
Item number 56.
Oh, it. You want to see? Huh? Huh? One minute. Let me check. I have signed all the orders. Almost, huh? Naipura. Sure. Okay. Heard Mr. O.P. Bhatti, learned counsel for the petitioners, and Mr. S.C. Kyle, learned standing counsel, CGST, for all the respondents. Mr. Bhatti, learned counsel for the petitioner, submitted that the petitioner may be allowed to withdraw the petition with the liberty to file FS. Mr. Kel, learned counsel, has submitted that he has no objection to the prayer made on behalf of the petitioner. So in view of the above submission made by Mr. Bhatti, learned counsel for the petition, the petition is dismissed on withdrawal with the liberty to file FS.
57.
Yes.
A plot measuring 1 bigha 6 katha being covered by DAG number 9512 and patta number 1471 is adjacent to the petitioner's land. The said land is belong to the respondent number 10. Respondent number 10 expressed her desire to sell the said plot of land. And being the adjacent neighbor, I approached her, and accordingly she informed me that she will sell the said plot of land to me, and she will apply for NOC matter. But subsequently, she applied for NOC to sell the said plot of land to the respondent number 8 and 9. I have submitted objection petition against the NOC matter. In spite of that matter, she was able to get the NOC, and thereafter I submitted another objection petition before the additional deputy commissioner to not to execute the sale deed matter. So in that objection petition, an order was passed, matter. Let me kindly come to page 44. This is a order dated 11th March 2025. Though it has been mentioned as 11 March 2024, but my lord, may kindly see the sign, my lord, 11/3/2025, below, my lord. So by this order, my lord, with reference to the subject caption above, I am to inform you that one Sri Dilraj Mozumdar, son of so-and-so, 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 and another one submitted 3 numbers of complaint petition against the land sale permission number so-and-so, so-and-so, claiming themselves of co-sharer of the land schedule mention of the land sale permission in question. In the above context, above mentioned 3 land sale permission are hereby kept in abeyance until further order. So in spite of this order, my lord, a sale deed was executed, backdated sale deed was executed at page 45, my lord. It's a receipt, my lord, Tuesday, 11 March 2025. So thereafter, my lord, now they are proceeded to demarcate the land, my lord. Against the demarcation, my lord, I have submitted an objection at page 46.
In fact, during the pendency of the objection, my lord, I have filed an case under section 164 of BNS, my lord. The order, my lord, will find at page 29. There is a restrictive order, my lord, page 29. Third paragraph. On perusal of the police report and on hearing submission made by the learned advocate of the first party, I am of the opinion that the dispute between both the parties in respect of possession of disputed land may lead to serious apprehension of breach of peace and public tranquility in the locality. In view of the above, I am satisfied to draw a proceeding under section 164 BNS and ask the both parties to file WS in respect of claim over the disputed land on the next date fixed, which is also fixed for hearing. Ask the local police to execute the order immediately and maintain peace in the locality. In spite of the pendency of this case, my lord, and the Captain Evans order, my lord, the sale deed was executed. So my apprehension, my lord, now, my lord, the demarcation, they will go for the demarcation also, my lord.
Did you brought this to the notice of the
Yes, my lord.
district magistrate?
Yes, my lord. This order, yes, my lord. Page 27/1/2025, my lord. Page 30.
Page 29, 30.
Page 30, my lord. Order date reference, order date 8/11/2024 passed by the additional district magistrate Kachar, Silchar, in case of so and so, so and so. With reference to the subject cited above, I have the honor to respectfully bring to your notice that on so and so, I have submitted an objection petition regarding land of so and so and others, which is adjacent to my residence. The owners of the aforementioned land are intending to sell it to another party. I am capable of purchasing the said land and have expressed my interest in doing so. As stated in my objection petition dated so and so, if the land is sold to any outsider, it would result in dispute concerning the access and uses of the private land but owned by me. This could potentially disturb the peace and tranquility of our area. In this regard, a case has been filed in the court of additional district magistrate Kachar, Silchar, and is currently under trial. A copy of the order date so and so passed by the so and so is enclosed here for reference.
Were there any, do you have any preferential right to purchase the land?
Only thing is, my lord, this is adjacent to my plot of land and the access to that land is belong to me, my lord. And I am ready to purchase it and I am offering to offering the value, my lord.
But whether that creates any right?
But since I have made an objection, my lord, and on the basis of that objection, a Captain Evans order was issued. Despite that, my lord, the sale deed was allowed to execute by the senior sub-registrar.
If something is kept in abeyance, if that is not vacated, and land sale permission was granted, but kept in abeyance.
Yes, my lord.
And he is saying that that order is not vacated. If that is so, then land sale permission also is a condition precedent. But after that execution of sale deed, did you bring those things before the
in fact,
district commissioner?
In
11 March 2024 is the kept in abeyance order.
Yes, my lord.
11/3/2025 is the sale deed registration.
Yes, yes, my lord.
We are in April.
Yes, my lord.
Have you brought this to the notice?
That, my lord, till the filing of this writ petition, my lord, it was not done because that information.
Because he is the appropriate authority. Because he is also the district registrar.
Yes, my lord. In fact,
Is it not?
Yes.
If it is without his knowledge, the sale deed has been registered by senior sub-registrar, you should have brought it to the knowledge of this particular person. And all these are also, yes, Mr. Usta.
Whether it was executed or not.
Okay, heard, Mr. N.J. Khatonia. Ingress and egress, it may be proceeding under 145 or 164 and civil suit.
Yes.
Not
Essentially, it's a civil suit, but
essentially it is a matter of civil dispute.
Only my concern is that in spite of a Captain Evans order, my lord, the authorities has allowed the
Only trade on which you can survive is the Captain Evans order. Otherwise, no other trade. No other trade to survive. No legal right, no preferential right that you can purchase the
Adjacent.
adjacent land,
That
just
is
being
there,
a
that-
neighbor.
That is there, my lord. In fact, initially that land was purchased from my
G
institute by the
Hazarika, revenue.
number 10, my lord.
All these are civil suit.
Yes, yes, yes. Essentially, it's a matter of civil dispute, my lord.
And Goswami,
227, Lord.
Nigeria government with Assam for the response number 227. Full stop. The petitioner is the owner of a plot of land which is situated adjacent to a plot of land owned by the respondent number 10. Full stop. The petitioner offered to purchase the land of the respondent number 10, and both the parties thereafter proceeded to a certain extent. Full stop. When the petitioner, but in the meantime, during the interregnum, the other private respondent, who 8 and 9, the respondent number 9 and 10 had entered into an agreement and thereafter obtained lands and permissions from the office of the
Additional district commissioner.
from the office of the respondent number 2. And the person who is in staging of the 164 proceedings,
Yes, my lord.
right, who has kept the order in abeyance, he is not a party here.
District. That is my mistake, my lord.
Or
Yes, ma'am.
to whom I should pass the order.
District commissioner is the party. My.
He is not he has not granted, he has not kept the order in
Yes, ma'am.
abeyance.
It's the additional district.
And
commissioner.
164 proceeding is also not before him.
Yes, madam.
He has passed the order. The authority who has passed the order in 164 proceeding, who has kept the NOC under abeyance, he is not here. A party who is not a party. What kind of direction?
I'll
This is
make the
difficult.
necessary. I'll
You
make
file
the-
amended cost title, otherwise it is difficult.
I'll make the necessary correction.
You have to file amended cost title nowadays. We
Yes,
file,
yes, ma'am.
otherwise, to whom we should pass?
Yes, madam.
You have made so many parties, but not him. Before whom, from whom you are getting favorable orders.
It's prior to not to dispossess the petitioner from the land. Not to dispossess. It's 20 not to.
That is, in fact, my pleaded case is, well, the position of some portion of land has already been given to me, my lord. That is my.
You file amended cost, Mr. N.G. Khatunian and Council for the petitioner has sought listing of the case on when?
Wednesday, my lord, Wednesday.
In order to enable him to file an amended cost title in terms of the notification dated so and so. Place the case accordingly, so and so.
Obliged.
Title 58. May it please your lordship. Now, look, the challenge before your lordship is arrest made under GST on 23rd of May 2023, your lordship, 25, my lord. The challenge, my lord, the challenge has been made, my lord, basically on, my lord, 7 grounds, your lordship. Number 1, my lord, the precondition as mandated under section 69 of the act has not been fulfilled. My lord, second, my lord, notice under section 41A, now it is on a 35 BNNS, has not been issued. It is in violation of judgment given by Honorable Apex Court in Ernest Kumar. And if the notice under section 41A has not been given, in that case, in Satyendra, until your lordship, Honorable Apex Court held that I am entitled to bail. Third, my lord, in the grounds of arrest, my lord, authority has not assigned reason. What is the necessity to arrest? That is what Honorable Apex Court in Radhika Agrawal that I have given, my lord, compilation of judgment, your lordship, held. Number 3, my lord, only to make, my lord, offense non-bailable. Authority has made, my lord, figure of 5 crore, because if it is less than 5 crore, my lord, it is bailable. If it is above 5 crore, then it is non-bailable. In that case, my lord, Honorable Apex Court in Radhika Agrawal held that assessment is required. Otherwise, assessment is not required. That I will place, my lord. In compilation, that judgment is there. In fact, in the similar situated condition, my lord, one of the petitioners approached this honorable court, and this honorable court was pleased to enlarge the petitioner on bail as an entry, and matter is still pending before this honorable court. So first, your lordship may kindly come to grounds of arrest, my lord. Page 60. An investigation was initiated in respect of so and so regarding alleged passing of ineligible ITC on the strength of invoices without actual supply of goods, wherein series so and so, the petitioner before your lordship, is the partner and responsible for the activities undertaken by so and so. You obtained GST registration of so and so based on forced rent agreement, and business was never conducted from the declared principal of place of business. However, you voluntarily statement made under section 70 of CGST has revealed that in addition to so and so, one more entity, so and so, different entity, is also operated by and managed by you. You voluntarily statement recorded your under section so and so has revealed that you, being the partner of so and sole operator of so and so, store has indulged in issuance of fake invoices and passing the of ineligible ITC amounting to 6.2 crore, so and so, which are punishable under section 132(1)(a) of CGST and are cognizable and non-bailable. If it is less than 5 crore, it is bailable under section so and so. Therefore, you are liable for arrest under section so and so. Further, my lord, for the statement recorded and so and so, it has been revealed that you were earlier arrested in GST evasion case in the past. All right, my lord. Further, no falsifiable explanation was furnished by you in respect of the non-existence of so and so, and it is declared principal place of business and obtaining GST registration on the strength of forged document. You were also shown so and so analysis on what wherein vehicles declared in you will seen to have movement in a direction different from the declared direction during the validity of e-way bills, establishing the fact that no supply was affected by the vehicles against which no possible explanation was furnished by you. Next, my lord. Involvement of other persons in the chain of issuance of fake invoices leading to evasion of GST has to be unearthed in the instant investigation. It is necessary to place you under arrest as per the provision of section 69 of the CGST Act to ensure fair and timely investigation. My lord, for the purpose of investigation, one cannot be arrested as held by Honorable Apex Court in Radhika Agrawal case. Moreover, my lord, as per their own circular, there are guidelines under what circumstances person may be arrested. If there is a, my lord, possibility of, my lord, tampering, hampering with the evidences, flight risk.
Let us understand your case thereafter. We'll go.
So, my lord, on this pretext, I was arrested on 23rd January, your lordship. Now, your lordship may kindly see I have given compilation of judgment.
What is section 69?
69, my lord, kindly see. Power to arrest. Where the commissioner has reason to believe that a person has committed any offense specified in clause A or clause B or clause C, so and so, which is punishable under clause 1, 2, and 3 or subsection 2 of the said section, he may by order authorize any officer of central tax to arrest such person. Where a person is arrested under subsection 1 for an offense specified under subsection 5 of section 132, the officer authorized to arrest the person shall inform the person of the ground of arrest and produce him before a magistrate within 24 hours, subject to the so and so. 132, my lord, kindly see.
Which thing? Yes.
132, my lord. Whoever commits or causes to commit and retain the benefits arising out of any of following offences, namely supply of goods or service so and so, issues of any invoice or bill without supply of goods, my lord, I fall under so and so. Evade or fraudulently obtain.
No,
refund,
which one?
It is not there.
What is your ground of arrest? What does it indicate?
My lord. Ground of arrest, my lord. They are saying fake invoice and taking ineligible, my lord, ITC. In 132, my lord,
Supply in services.
इसमें राधिका देखिए
Yes.
now your lordship may kindly see, or if the amount is below 5 crore, my lord, then it is bailable.
Where?
My lord, section 132, and your lordship may skip over. These are the offenses shall be punishable in cases where the amount of tax evaded. Your lordship has got it, man. Shall be punishable. Clause 1. After describing the punishment, thereafter, my lords, in cases where the amount of tax evaded or the amount of input tax credit wrongly availed or utilized or the amount of refund wrongly taken exceeds 500 lakhs with imprisonment for a term which may exceed to 5 years and with fine. In cases where the amount of tax evaded or the amount of input tax credit wrongly availed or utilized or the amount of refund wrongly taken exceeds 200 lakhs rupees but does not exceed 500 lakhs rupees with imprisonment for a term which may extended to 3 years with fine. In case of any other offense where the amount of tax evaded or amount of input tax credit wrongly availed or utilized or the amount of refund wrongly taken exceeds 100 lakhs rupees but does not exceed 200 lakhs with imprisonment for a term which may extend to 1 year with fine in cases of so and so thereafter, where any person convicted for an offense under this section is again convicted under so and so, he shall be punishable for a second or so and so. Your lordship may skip over. The imprisonment referred to in clause so and so shall be in absence of a special or adequate reason to the contrary to be recorded in the judgment be for a term not less than 6 months, not extending anything contained on except the offense. And clause 5, my lord, I fall under clause 5. The offenses specified in clause A or clause B or clause C or D or subsection 1 and punishable under clause 1 of that subsection shall be cognizable and non-bailable. Other offenses are, my lord, if it is less than 5 crore, it is bailable. Now I am coming to the coordinate bench interim order that I have given in INEX with petition also. I have given in my compilation also, my lord, page 1 of my compilation. In the similar situated condition, one person was arrested and this honorable court, after taking into
Which one? Page?
Page 1, my lord, of my compilation, my lord. Here it was in that my case it is 6 crore. Here it is, my lord, 10 crore, para 3. Page 2, para 3. After recording judgment given on Honorable Bombay High Court, that also I have, my lord, given in compilation. And in the entry, my lord, I was enlarged on bail, your lordship.
On what ground it is granted?
Granted, my lord, that 41A was not taken into consideration. Court has.
Where it is discussed? 41A.
41A was not taken, reason to para 16, my lord. Page 5, after recording judgment of Honorable Bombay High Court and which was upheld by Honorable Apex Court, my lord. Page 5, para 16. There is no attempt or tampering of evidence on that ground, your lordship.
No, which paragraph? Your
Para
paragraph?
16, my lord, page 5 of my compilation. 1-6. The requirement, it starts from the requirement. Your lordship has got, my lord. Compilation. The requirement of subsection 1 of section 69 is to have reason to believe that not only a person has committed any offense as is specified, but also as to why such person needs to be arrested. From a perusal of the reasons recorded by so and so, we find that other than the reference of requirement of section 41 CRPC, in that no concrete incident mentioned therein, recording any act or attempt of tampering of evidence by the petitioner or threatening, inducing any witness beside not cooperating with the investigation. In such a circumstance, we are of the view as so. What has taken?
What was recorded therein?
Nothing except, my lord, that for the investigation purpose, I am required. Your lordship will see.
No, it is not there only.
I have evaded.
No.
They are saying I have evaded, but they are not saying that there is a possibility of tampering or because their notification that I will place, my lord, it says it is the requirement of arrest, my lord. Why then there is a requirement of my arrest, my lord? Search and seizure operation was taken place. In that day itself, I was arrested. It is not that I was called, I did not cooperate. No notice, punishment is less than 5 years, my lord.
Huh?
Punishment is maximum 5 years, my lord. In that case,
yes.
Ernest Kumar says, my lord, 41 notice is mandatory. And Satandar until said non-compliance of Ernest Kumar entitle me for granting bail. And Apex Court in Radhika Agarwal says, for the purpose of investigation, one cannot be arrested under GST. There is no mention.
What is Radhika Agarwal?
My lord, in my compilation, my lord, it starts from my lord, the page one, page 12, my lord. And my lord may kindly come to para, it starts from para 49. Page 41. First, your lordship will see. Your lordship may skip over, yes. Para 50, your lordship may kindly see. To a large extent, our reasoning and ratio on the applicability of the Code of Customs would equally apply to the GST Acts. In view of section so and so of the code, subsection 10 of section 67 of GST Acts postulates that the provisions of the code relating to search and seizure shall, so far as may
Which
be
paragraph
applied.
you are reading?
Page 41 of my compilation, para 50. Because I have to read my lord 4 or 5 paragraph.
Do we have larger font size?
My lord,
Do you have larger font size document?
this judgment concept.
No. This I
Yes,
find it
yes,
very
yes.
difficult.
SSC online, my lord.
I don't go by SCC online. If it is SCC, okay. Otherwise, the Supreme
SCC,
Court
this is
decision.
SCC, my lord. It is
Do you have any big one, bigger font size?
bigger.
That also I do not want to put stress on my eyes.
Single.
If lordship allow me to intervene, management allow.
My lord, I will
Lordship,
take. I will take my 15 minutes at least.
15 minutes or no? Let me find out. Yes, what do you say? 1 minute
Lordship,
for Mr. Kyle.
page page 67, lordship. No, lordship, sorry. Petitioner approach this honorable court for filing bill application.
Earlier we approached by
Page 63, lordship.
that was annexed.
Yes, it is annexed.
Huh.
He approached this honorable court for filing bill application that was rejected. Lordship, please to see.
Hmm.
Paragraph.
Oh, 18.3.
Page 65. Paragraph 5.
Page 60.
65. Paragraph 5. Having heard the learned counsel for the parties and on perusal of the case diary, it revealed that the petitioner is the proprietor of Ellis Company, against whom the allegation was made, evading payment of total GST amounting to crores in rupees. Learned senior counsel for the petitioner paid to release the accused on bail on the ground of length detention, that is 54 days in judicial custody, wherein the mandatory period is 60 days. It is not to dispute that the alleged offences are punishable with imprisonment up to maximum 5 years and compoundable in nature. Paragraph 6. However, it appears that another case being number so and so is pending against the petitioner in the court of Athesium 1 Kamru. What it transferred that the petitioner is a habitual offender and the petitioner being the proprietor of foresaid companies that is indulged in committing the offense as alleged. Hence, the court is not inclined to grant bail to the petitioner. Therefore, bail application is rejected.
No, this is in the same case.
Same
Yes,
case.
same
My
case.
lord, we in
No,
that
no,
case we have
just
not
I'm-
challenged, my lord.
All
Bail.
right.
Arrest.
Thereafter, Lordship, we filed.
Just I'm asking you, this
Yeah,
is on
same-
18.3.
Yes, same case.
18.3. That on that day it is 54 days,
Yes, sir.
right?
Thereafter,
Meaning
Lordship,
thereby 60 days expired. So you are entitled for default bail.
They filed.
Lordship, in the meantime, we file complaint. That is, complaint number is 171/2025. And it is filed on 18/3/2025. And next date is fixed on 24 April 25.
No, are you entitled for default bail?
No, at this stage is not entitled because the complaint was filed within.
Oh,
6 days.
complaint was filed.
Yes, sir. It was filed
It
on
was filed.
18/3/25.
Then it is the jurisdiction of that court
My
Yes,
lord,
sir.
here.
on that ground,
My-
This is my humble submission.
on a default ground.
Exactly. I am not on that, man. What I am submitting before your lordship. The challenge before your lordship is the very legality and validity of arrest. Whether, my lord, the judgment as given by Honorable Apex Court in Radhika Agrawal, subsequent judgments, where
Let me go
complied
through
with
it.
or not.
We'll put it on
Num-
Monday. We'll go through it, all these bunches.
My lord.
Because now there is another right. By the submission of the complaint, within say 60 days, it is akin to 167, right?
Now,
That right is lost. and it is, any bail is to be granted on merit. That court also has the jurisdiction. So far as legality and validity of the arrest is concerned, we have to we can examine perhaps,
My-
right?
Because the
So
same,
sitting here and going to these judgments, long judgments, not possible for
My-
a court.
that's why I have compiled, my lord.
It may be taken on Tuesday. Lord.
Tuesday. Okay.
I'll come with the or
Better, whatever is there.
Yes, sir.
If the order of arrest itself is illegal, that is
My
a
lord,
different matter.
everything will go, that's,
Otherwise, after, if
otherwise, my
that
lord,
default bail that gone, now it is for on merits.
my lord, may I submit, man, so far as another case is concerned, in the case of Natwar Jalan, which is pending, where this honorable court was pleased at the very first day.
Very first day,
Not on very first day, Lord.
not, perhaps not very first day, it does not look like
First
very
day,
first
sir.
day, Mr. Goel.
It was very first day, my lord. That
And
record may be checked.
At that time, Lord, Radhika Agarwal was not there.
Yes, not there, but the interim order was granted. Radhika
Okay,
Agarwal is in my favor.
At least let me have the
My lord,
full
Radhika-
opportunity of reading
If-
Radhika.
My lord, if your lordship will go Radhika, Arnish Kumar and Satyendra until my case is over, your lordship. Then my
Here
lord,
the
nothing to
question
say.
is regarding the legality and validity of the arrest.
My-
And that is taken into consideration by the Honorable Supreme Court. Everything has been discussed.
That's why. That's why I
Let
want
me
my
have the
my-
full view of the
Yes, that is
Radhika
there.
Agarwal.
Radhika Agarwal, Arnish Kumar, Satyendra until reason to believe judgments were also given, my lord. And Radhika Agarwal, my lord, Honorable Apex Court held, my lord, reason to believe has to be based on material, number one. What is the only reason to believe will not do the purpose? What is the necessity of arrest? It is also required. And as per their own circular, Mara, where it says that if there is a allegation that of tampering with the evidences, my lord, influencing the witnesses, in that case, arrest should be made. That notification is also quoted in Radhika Agarwal. So I will be happy if your lordship will go
And
through.
Lordship, in last part of the judgment, by authored by Justice Bela Trivedi, it is said that judicial review cannot be lightly interpreted. In case of arrest, judicial review is very limited power is there.
Concurrent
Okay, sir.
judgment, my lord. In fact, it is also in my favor. It says that if the arrest per se is illegal, 226 and 32 is the only resort.
Lordship may peruse the judgment.
My
If
lord,
it is-
that's why I have given compilation, my lord, where all the judgments have been compiled, my lord.
Long judgment, we
Yes,
have to
it is.
read.
But para 49 onwards, my lord, Radhika Agarwal. Before that, they have mentioned about custom because both the acts were taken together, my lord. Para 49 onwards.
Lordship, interestingly, Lord Supreme Court mentioned that paragraph 31 to 47 will be applicable in case of GST. also.
Yes,
That is to be taken into consideration. Everything is in discussion.
even CRP, because GST is not complete code, it is also mentioned. GST Act is not complete code.
Okay.
So recourse of criminal procedure code is necessary and 41 is applicable. That they have not done, my lord.
I'll produce everything, Lordship, whether we have complied with or not. then
Okay.
we have-
Purpose of 41 while calling, same day going and arresting and giving notice, it is not 41.
Heard Mr. A. Goel, learned counsel for the petitioner, and Mr. S.C. Kyle, standing counsel, CGST, for the respondents. First of, Mr. Goel has submitted that he will rely on the judgments based in the compilation, first of. Where Mr. Kyle has submitted that case be listed on Thursday,
No, Tuesday, my lord.
sorry, Tuesday,
Tuesday.
in order to complete his instructions. As sought for, lays the case on 8/4.
Deeply.
Radhika Agarwal, Radhika.
59.
Please. Put to be my two board.
Madam, there is a caveat.
Yes.
Madam, I was the chairperson, the chairman of the
Municipal board,
Markham Municipal Board.
okay, municipal, yes,
I was removed by following a procedure in a meeting. The proceedings have not been given to me or any order, therefore I could not annex it. I've made a statement. Am I audible, Madam?
ah,
On 2 counts, I'm assailing the process. To remove a chairman from his post or her post the procedure is laid in the act. The first, which was there, 28-1.
28-1.
28-1 is no longer there.
28-1.
That is no longer there.
Hmm.
28-1 has been removed, deleted. It was the government could remove at any point of time. Now 28-2, an elected chairman or vice chairman may be removed from his office by a resolution of the board in favor of which not less than half of the whole number of commissioners shall have given their votes at a meeting specially convened for the purpose.
And what about a notice? Notice.
Notice to me, yes. I'm coming on that. This is an elected chairman by a resolution can be removed. So there are 10 commissioners. Since 7 had issued the notice for no confidence, they would have the majority. That's not the problem. Number 3, Lordship comes to 28-3. The state government, after giving an opportunity to explain, may
That is a
remove.
different purpose.
What I'm on is
That is for misconduct. That is not here.
correct. What I'm on, my lord, is when a notice is issued to the chairman, whether he holds the meeting or the vice chairman holds the meeting. In
Let us
Panchayat,
see the meeting.
yes, I'm on that. The penultimate meeting proceedings are not there with me, but so far how it initiated at page 20.
What is the provision for calling meeting?
Provision for calling meeting is not there. The provision is rather otherwise.
It is there.
That would come subsequently.
No, no convenience.
For no confidence. my lord.
Yes.
If Lordship comes to my lord, 41,
How many days?
20 days.
Tell me the
It-
provision, Mr.
Wait, wait,
Colleague, don't
No,
go here and
I'm
there
saying-
calling for how a requisition is to be submitted. Please come to that.
Absolutely, my lord.
Please.
20 days would come.
Where?
if
Which
the
is the
vice chairman
provision?
coming there. 43-3. 43-3. If I may read, my lord.
2 also.
2 also. The chairman, or in his absence, the vice chairman may call a special meeting whenever he thinks fit and shall call one on a requisition when not less than 3 of the commissioners. Yes, 7 had come.
Yes, now tell me.
Now, page 20.
Twenty-seven 2025.
27.
How many?
7
Before district commission.
before district
Okay.
commissioner. That
Done.
that would not be in terms of the act, my lord.
Done.
Now,
Now, what about page
17
27?
17-2.
Ah,
17-2, page 27.
directly to you.
That was directly to me.
20 days? You go, add 20 days?
Absolutely.
Add.
What I'm on is that.
Add 20 days first.
I have done that, my lord.
Done.
5th would come.
We reach?
Then-
We
then-
reach?
5th.
5th of March.
5th of March.
Okay, done.
Now,
Then
what
what
I-
happens?
Then at page 34. Page 34.
Date?
20th of March. 20.
Yes.
They
Done.
write to the vice chairman
Done.
to hold a meeting.
Done.
Now, in terms of that, 20 days comes to vice chairman to hold a meeting.
No. Then
Then they issue a notice at page 20 at 36.
page 36, 26, 3,
26,
2000.
3.
When meeting was
27 it was held.
27 was held. Did
27
you attend the meeting?
I did not attend the meeting.
It was served to you.
It was served to me.
Served to you.
It was served to me.
Then
No, what I'm on is that. I'm thinking,
end of the matter.
one view, yes.
End of the matter.
What I'm trying to place, my lord.
Whatever has been proceeded with.
What I'm trying to submit, my lord, is that.
Vice Chairman did not act. It is not up that. Section 43, subsection 3. The meeting may be called by the persons who signed the requisition.
They can do it.
They can do it.
But-
They have done it.
They have done it at the behest of the jurisdiction deputy commissioner.
No, is there any direction?
Yes,
Where is that?
page 36. Page 37. Page 37. This notice is issued in compliance with the directive of the Honorable Deputy Commissioner and in adherence to relevant provisions governing the municipal administration.
This notice, which one?
Page 37, the notice at page 36, my lord.
Hmm.
May I read page 36 for a moment? It would come up, my lord. Whereas a petition dated 17/2/25 was submitted for the initiation of.
He
a
is not
record-
interfering with. Hard.
My lord, what I am on, if I may please, my lord, lordship is taking a call. I'm not on that. I understand where I'm put today. So far as the chairperson, a chairman or the vice chairman to call the meeting. If we need the parallel provisions under the Panchayat Act, I'm on.
No panchayat.
There, a provision is laid down who is to call the meeting. Here, in case of chairman, when he goes out, he does not preside. To the extent there is no right of hearing, there is nothing.
Notice served admittedly.
Notice, sir.
Ah.
But 20 days count whether it would come from 20th
No.
of March,
No, no.
because the vice chairman
No.
is to preside. I had nothing to do.
You were given 20 days time.
After 20 days time, that is my sole submission, my lord. In a meeting of no confidence against the chairman, the law does not prescribe a procedure where
I have whole already, that has been affirmed by the division bench, so I'm not,
I'm understanding. my lord.
I'm not interested. You get it, set aside. But, Mr. For the persons not required. You were granted that liberty to call the meeting within the period of 10 days, 20 days. Apparently, you have lost the confidence
But losing the confidence. per
and
se- Yes, 7.
call the meeting, and privacy, it looks like in accordance with the provisions of the Assam Municipal Act. And it is not that they have approached the district commissioner just to have the permission.
Permission to hold a meeting was not
No.
necessary for the, if they
Okay,
President,
that will be decided later on. But you have lost the confidence of how many out of 10?
10.
7,
Well, so far as,
including you, 8.
so far as,
It appears vice president is also with you. 9, another one.
well, so far as losing the confidence, if they come and say we have lost the confidence, one thing, but stigmatic allegations being there in the notice and coming to that, the vice chairman is not holding within the
That
20 days. period, my
stigmating
lord.
is,
I don't have a right of audience, my lord.
Huh?
Under the act, if an elected
no,
chairman, I don't have right of audience.
no.
That goes.
If you appear, and if you are able to persuade the persons addressing the meeting, moving the motion, no, it is not there, it is implied.
It is, if it is very.
If you can persuade, they may withdraw the no
But
confidence
it is-
motion, or otherwise they will proceed.
To that, it is given only the.
It is not a
instance.
case of misconduct. Misconduct is different. For that, you have to give a notice.
My lord,
That person,
it boils
I think
down
the
to
law is quite subtle.
But may I read the notice given to me? The statement.
Whatever, ultimately it is a no confidence motion.
Ultimately, what they have given.
Notice for convening a meeting regarding no confidence motion.
The 17/2/25, when it was given to me, what were the allegations on record, whether it amounts to misconduct, that lordship may kindly have a look.
No, it is a clear case of, there are two things. One is no confidence, one is misconduct. For misconduct, yes, state government has the power to remove. 28, I think, you have just read.
Three.
Huh? That, for that purpose, you have to give in all the opportunities. But so far as no motion, no confidence motion is concerned, nothing matters.
There is a 19.
If you lost the confidence of the majority, requisite majority, matter ends there.
But so far as the allegations brought in. the
And I have
notice-
already held that there is no clearance from government, district commissioner. If majority passes the order, it takes effect
I understand.
right at that point.
Pausing for a moment, my lord. There's an earlier judgment, quite earlier judgment, 1971 or 72 judgment, which I have, my lord. It talks about the status of a chairman elected or
We'll
otherwise.
hear at
that was-
at the final stage. At the final stage, all these submissions. We are primarily satisfied
they-
that
The act does not lay out a right for hearing. It says the questions to be determined by the majority of votes. And the judgment says it has to be akin to that, and the right of hearing is a must.
which one?
There are two things, my lord.
Right. And
The
this
right of-
moment I am not been able to lay out my hands on my own decision.
I
I have already held and I have already affirmed. In case of no
Whether it is
confidence,
judgment-
no, absolutely nothing hearing.
Whether this judgment was
If
taken into consideration.
somebody, by attending the meeting, is able to
Yes,
persuade,
yes. To that extent, yeah, I
it
understand.
is, if the persons who is moving the motion, if they are satisfied, they can withdraw the motion. But if they goes ahead and is against you, gone. But so far as complaint is concerned, or
This was in the nature of
rem-
the complaint.
no, it is ultimately motion of no confidence.
That-
No discussion is required on the
Absolutely.
complaint. And it is not stigmatic, sir.
It comes again.
It is not stigmatic.
With the complaints coming along.
We'll hear at the time of final hearing. It is not stigmatic, sir. No confidence motion is not stigmatic.
But I,
It has been held by long line of decision.
I bow down to your lordship.
Many things are written in the requisition.
Yes.
This, that. Ultimately, he should be removed.
To that extent, the questions
is
can
not
be
a complaint.
determined by majority. The signature is enough, my lord. The
But
questions come to this, my lord.
it is a democratic institution. It has to run by democracy. It has been held time and again. I think in many of your cases also.
No, but
Perhaps
even-
of Mr. Bonig also.
70
Heard Mr. S. Bonig, learned counsel for the petition. Who is Mr. Islam you are for?
4 to 10. I have to.
4 to 10.
Caveat is there.
Or that the requisition is? Okay. And Goswami. What about 1 and 2? Okay. And Mr. S. Islam, learned counsel who has entered for the respondent number 4 to
10.
10 on the statement of a caveat stands research. First of the in the election held for the ward commissioners to the Makum Municipal Board, District Tinsukia on 6/3/2021, the petitioner got elected as one of the ward commissioners along with others on 9/3/2021. Post of thereafter, the petitioner got elected as the chairperson of the Makum Municipal Board, which consists of 10 number of ward commissioners. Full stop. On 27/1/2025, 7 number of ward commissioners of the municipal board submitted a requisition before the district commissioner Tinsukia, expressing quantum confidence in the petitioner in the capacity of chairman of the municipal board. So thereafter, on 17/2/2025, the same 7 number of ward commissioners submitted a requisition before the petitioner in expressing lack of confidence in the petitioner and request that the petitioner to convene a special meeting to discuss the motion of no confidence. First of thereafter, on 20/03/2025, the same 7 number of ward commissioners who are responding number 4 to 10, had submitted and submitted a petition before the vice chairman, Makum Municipal Board, for initiation of a no confidence initiation of no confidence motion against the petitioner. First of, it was thereafter on 26/3/2025, comma, the 7 number of petitioners, award commissioners, as per number bracket 10 to 4 to 10, served a notice upon the petitioner. First of, from the contents of the notice dated 26/3/2025, comma, it can be noticed that the notice was served upon the petitioner informing that a special meeting had been convened on 27/3/2025 to discuss the motion of no confidence brought against the petitioner by the 7 number of ward commissions. Full stop. Anything thereafter?
They held the meeting on 22nd,
Ah.
and thereafter I'm told, my lord,
Thereafter, the meeting was held on 27/3/2025 as scheduled. Full stop. Anything more?
thereafter I'm told that they had issued a notice for election of the new chairman, but
Second meeting.
it was not held.
Okay.
I mean, held.
The petitioner did not attend the special meeting held on 27/3/2025. Full stop. The petitioner has submitted that the petitioner has come to learn subsequently that after the meeting, special meeting on 27/3/2025, another meeting is being contemplated to elect a new chairman of the municipal board.
Today they have.
First of-
Response number 6 has taken the.
Okay, issue notice returnable on so and so has appeared, so and so, so and so. Shall I hold on interim pair? Huh? Mr. S. Islam, Learned Counsel for the response number so and so, caveators, has referred to the provisions of section 28 and section 43 of the Assam Municipal Act 1956 as amended to submit that the procedure followed till the holding of the special meeting on 27/3/2025 are in accordance with law. Full stop. Issue notice returnable on so and so. If I observe something,
Fine.
I have to observe. Then you can go for appeal.
Item number 60.
Yes.
The petitioners in this case are aggrieved by the fact that the respondent authorities are constructing a wall.
Respondent authorities, who are the
Respondent authorities,
respondent authorities?
3, 4, and 5, Lordship.
3, 4, and 5.
2, 3.
Where they are constructing?
The construction is in Namrup, Lordship.
No, where? One kind of land. Petitioner's land.
No, petitioners not land, but
Ah.
it is also a disputed matter. Kindly peruse the page number 27, Lordship.
No, it is not your land.
It's not my land,
Somebody else's land.
but
Maybe
not-
government land, maybe
Yes.
somewhere.
Yes, somewhere land.
Why, how you are aggrieved?
But we are aggrieved because of the fact that we are facing immense difficulty
Ah.
as the right.
It
to
is your
pay-
Patta land.
No, not proper. We
Oh,
have,
you are also not Patta land.
Lordship, we have applied for settlement.
Oh.
Yes, we have kindly peruse the page number 27.
You are also on oxygen.
But we have been residing in the land.
We'll
is-
issue notice also in the interim, let them come.
Lordship, but the thing is that the wall will be-
You are not also owners. They are constructing wall in some other land,
Yes, Lordship.
right?
Yes.
What right, with what right they are constructing, we don't know.
Lordship, if the construction is complete, then we don't have any paths to go out and ingress and egress, Lordship. Lordship, we are not against the construction of the wall. We are only against the fact that they have not let any provisions left for going out and in.
Okay,
Lordship.
if necessary, we'll put a hole there in the wall.
No, sir. Lordship,
Okay.
they are constructing a precast wall and it will be completed within 7 days, Lordship.
Okay, we'll put a thing that to
Lordship,
have
I-
ingress and egress at least till the returnable date, Mr.
Lordship,
Constructed by APGCL.
APGC, yes.
This should be expert again. APDCL council?
Where can it not?
Huh? Assam, Assam Power Generation.
Generation Corporation India. APGC.
They have a standing council, I think. Assam Power Generation or Assam AEGCL?
APGCL, Lordship.
Huh? One is APDCL,
One is AEGCL.
AEGCL.
This is APGCL.
Then this is APGCL. Whether they have any standing council?
We have issue, cause list, it is shown in the cause list, Lordship. Standing Council AGC.
AEGCL, it is shown AEGCL.
This is APGCL.
Now you are implementing APGCL,
APGCL, yes, Lordship.
not AEGCL.
It is the same.
No,
But
no.
we issued to the APGCL also. already.
Respondent is APGCL.
Yes, we.
NTPS is also there. Look.
Find out from any standing council of APGCL who is, sorry, APDCL, who is the standing council for APGCL. Then only we can. Huh? You served upon AEGCL.
Lordship. Lordship, let the matter become after some week time.
Find out.
Lordship.
Any standing council is there.
Lordship.
Yes.
Obliged, Lordship. Timing.
Timing matters. Item number 3.
Yes, more.
We have received an your lordship. It is done, your lordship.
Done.
Redressed,
Grievance redressed.
Did this?
Redressed.
Close.
Yes. They have accepted our position.
Good.
There are
Hard-
several anomalies, Lordship.
Huh?
There are several anomalies.
No, we cannot go into
Yes,
this.
yes.
This
But
is,
our-
we are not here for
yes.
field inspection. We
Yes,
can
yes.
only observe that, look into the
Yes, yes.
grievance. Try to read this. Okay. You've got copy.
Yeah, I have got instructions.
Okay, just we'll keep it. Heard Mr. M.H. Loskar, Learned Counsel for Petition, and Mr. Otherwise, if we issue notice.
Yes, yes, it would have gone a long way. But at least they are.
And K. Cole, and additional Advocate General and Senior Standing Counsel, Panchayat and Rural Development Department. And Miss A.B. Kayas Ardube, Learned Standing Counsel, Assam State Election Commission. First off, Mr. Kuhn and Mr. Dubey were asked to obtain instructions in the matter regarding the grievance of the petitioner with regard to non-disposal of the rectification application submitted by the petitioner in terms of the order dated 6/2/2025. First off, Mr. Kumar has submitted today by placing an office letter number so-and-so dated 4/4/2024 of the
Electoral registration officer.
what is this?
Yeah.
This is who?
Electoral registration officer.
Uh,
Just below the signature, it is written, but actually signature.
From
Yeah.
the office of the Bhairav Nagar Development Block. That the that after field verification, the case of the petitioner was considered and his polling station has been changed to 53/4.
Yes.
First off. Done, Mr.
Yes, sir.
Polling number, okay. Mr. Loskar, Learned Counsel for petition submitted that the grievance of the petitioner has been effectively redressed in the meantime. First of, in view of the above fact situation, this contempt petition is not required to be proceeded with, and accordingly, it is accordingly closed.
Obliged.
Item number 5.
Yes, Model Degree College.
My lord, request your lordship to look into the order dated 19/3/25.
I think Mr. B. Chaudhary. Yes, yes. Who was asked to obtain instruction?
Already we have the inspection.
Ah.
Lordship, here, PWD has got not so much role as per the pleadings, Lordship.
Who has laid the foundation stone?
District Commissioner.
But these lands are made government cast land in 1982. According to them.
According to them, let them file an affidavit on this para.
And your father and your uncle's name have been removed. They were earlier Khatian holder since 1982. So we have traveled 50 years, I think. 50 years since 1982.
My lord, if I can, with your lordship.
Absolutely no agricultural activity.
My lord, I take it what they have stated, though I have not got the affidavit. My lord, what I want to place it, if it is in the 82, it is a khas land. Till today, we are in possession. Section 6 of the regulation will come. 82 till today.
But so far as
I hold, my lord, as in Salakuddin also it has been described that under Section 6, I can acquire the right of a landholder, settlement holder, and others. Because 26 of the Limitation Acts will come into play, man.
no, what is your case projected?
Para 14.
Sir, para 2, you based your case on Khatian, 1978.
Well, 70.
Those were gone in 1982.
My lord, if it is Khatian also, my lord, thereafter, my lord, they have done it as a khas land, but we are in occupation. If it is a khas land also, my lord, that Salakuddin will come in.
We have to see about the public project and public private interest also.
My lord, that at this moment, my lord, my bona fide claim, my representations were pending. They should have given a reply to that. My lord, page 51 onwards.
Had it been a, because your whole case is based on Khatian.
Khatian, my lord,
Khatian is gone in 1982.
my lord, thereafter, it is a khas land. In 82, it was a khas land, my lord. Now this, as per 82, they should have removed me. Now they cannot allow me to hold the right of.
No, if it is reserved for public project.
No, it was not reserved for public
That
purpose. It
was
was a khas land.
Where is that?
It was not reserved for public purpose, my lord. It was a khas land. That is what I understand from their. In
Eastern Command, so and so. What is page 20?
Page 20. That was the draft Khatian and the Assam temporarily settled area tenancy act of 71. Yes. One chance of controverting it, my lord. What just now my friend has given me a copy of the Parawise comment. They have said no agriculture activity on the government land is found since long. They are only occupying the.
You don't have any houses also?
My lord, my
I think no, you don't have any houses. It is clear vacant land as per your photographs only.
My lord, they
then if anything is because absolutely clear.
My lord, at least
come to page 49.
My lord,
If you are entitled to any compensation, definitely you will be getting. But page 49.
It is as crystal as water. My lord, that I understand, my lord. But only thing, my lord, if
You, because it looks like no agriculture activity.
no,
It looks like vacant,
my lord,
right?
my lord,
It is a government khas land
my lord,
and your claim is 4 bighas.
my lord, my lord, my lord,
4 bighas, no structure.
my lord. I understand whatever
That
your
one,
lordship said.
I don't know in what,
Only
in
thing, my lord,
what
they
in,
admitted one thing,
there is a goalpost. People used to play football.
my lord.
Football.
Can I ask one thing, my lord? My lord, one submission. My lord, they have admitted in their parawise comment, I am occupying the government cast land.
Definitely you will get the
My lord,
money.
I am not asking, my lord, what?
Because I was concerned with something which is going to be damaged.
My,
Right. I think that was the previous
My lord.
deliberation.
my lord,
If I remember correctly, sir.
my lord, what I understand, my lord, if my lord, regulation 6, Assam Land and Revenue Regulation says, I acquire right through adverse position also, my lord.
Oh, no.
My lord, that is,
That light is different.
my lord, because they are saying that I am in occupation of that. My lord, it is there.
No, it was prior to 2019.
No.
Yes.
No.
Yes, I was talking about it was talked about the father and other.
Father was a
Yes.
Khatian, and now we are occupying the government
No.
khas land since 82.
And it's
30 years. And my lord, it has been described in the Salakuddin by division bench.
I have annexed, even though it is not so much legible, the part of the.
Let them file an affidavit, my lord. I will.
File, but
Definitely we will.
public interest must give way to individual interest.
My lord, they have here.
Considering them, I thought that you have, because I understand that something is going to be damaged. With that
My lord, but they are
situation.
admitting to the fact that we are having a khas land, we are occupying a khas land.
Okay.
My lord, your lordship may just look, if your lordship permits me, that Salakuddin judgment, my lord, where they have stated that under regulation 6.
Don't bring Salakuddin everywhere.
My lord, because my lord, the statute provides that I acquire the right by section 26 of the Limitation Act. The statute provides, my lord. Your lordship may look into the section regulation 6, my lord, which was argued before the division bench, and the division bench held, because that is the bona fide right. Because that is the bona fide right which through I file an application. My lord, they have to decide my bona fide right before throwing me out. Rule section 26 of the Regulation Act, I can acquire right through landholder, settlement holder, or through section 26 of the Limitation Act, which was placed before the division bench, where the issue was whether notice has to be given or not. And the division bench here, notice has to be given. They are saying in their parawise comment that I am occupying the government cast land. Maybe in 82, my lord, the subject to all my restriction, my lord, I am placing this submission. Well, because I don't have this parawise comment with me, man. And my representations were there. Whether before evicting me, they should have given me a notice. When they are saying that I am in occupation of the cast land. In the parawise comment itself, they are saying, man. Regulation 6, my lord, regulation 6 of the Assam Land and Revenue Regulation, my lord. Right which may be acquired over land. Your lordship is well aware of that fact now. 6C, right acquired under section 26 and 27 of the Indian Limitation Act.
Come to your khazna.
My lord. Relevant portion given, my lord.
Page 28 perhaps.
My lord. May I submit one thing?
No,
my lord?
please explain this page 20.
My lord, here also, if I find it out, my lord, here page 27, Assam schedule. If it is
I usually go by the original one.
original,
That
is my lord,
I
page
already go.
28.
If I find any mistake, every mistake will be
My lord.
cost you 100 rupees.
My lord,
Huh.
this is page
Page
28.
28. No, patta number.
Patta number.
Huh.
Boi number,
Yes.
Shamik number.
Which, it pertains to which document? Which land? This page 28.
Page 28, my lord. In our, my lord, Khatiyan number, Purani Dag number at
No,
page
no,
20.
page 28 of the read petition.
My lord, that is, I'm seeing, my lord, because I'm looking into my Khatiyan also. Draft Khatiyan
No,
also.
you explain patta number Miadi, act number patta.
Act number patta.
This goes with paragraph 3.
Paragraph 3.
Petitioners are also regularly paying up to that land revenue up to the year 2023 for the said plot of land.
My lord.
And this revenue document, paying document is pertain to that land. And it shows patta number, act number patta and Miadi.
Miyadi, my lord.
Uh,
My lord,
Please explain this.
here it is at page 28, my lord.
Page 28.
So,
First you explain.
It is Chota Manda Grand. At the left hand side, Ramen Nam, Chota Manda Grand, Miyadi, Act number Patta. In the
Chota
second
Manda.
Patta the number, Act number Patta.
Chota Manda.
Chota Manda
What is
Grand.
patta? Where is patta?
My lord, page 28, third column. Patta number, Miyadi Patta, Act number Patta. Page 19, your lordship may look into also. Page 19, and your lordship may look into page 20. Page 20.
And any prior document in
Page
between 1950?
Page 20, my lord.
Because you are paying khazana for last 10 years only in 2023.
My lord, page 20, your lordship may look into.
Page 20.
Right hand side, my lord.
That I have seen. Now in between.
In between, my lord, I don't find any documents.
Place document. File additional affidavit. Monday will take up.
My lord.
Right. So in between, in the interim for last 50 years. In 82 to
My lord, in
2023.
my lord, it's my duty. I will definitely.
Because
My lord,
everything is
only
filed and
thing
now they have come up with 82. We are in complete dark about last 50 years.
My lord, can it be on Tuesday, my lord?
Not Tuesday,
No, we have to-
Monday or Wednesday.
Wednesday, my lord. Only thing, my lord, can this interim order be till Wednesday, my lord? Nothing will happen, my lord. Nothing will destroy them, my lord. Nothing, what they are doing, my lord, I place it.
There is no eviction as such.
My lord, this is-
There cannot be a protection.
This is what they are doing, my lord. I'm placing the photo. This is what
Part
they are.
Mr. P.K. Rochuri, learned counsel for the petitioner, A. Verosaiji, sorry, G. Hazarika, Revenue and Disaster Management Department, S. Borua, learned Junior Government Advocate Assam, 2, 3, 4, and 5, and Mr. B. Chaudhary, and standing counsel PWD for the respondent 6, 7, and 8. Post. Para, Mr. Borua, Junior Government Advocate Assam has submitted that he has received instruction from the preliminary instruction from the office of the Deputy District Commissioner Kachar, wide office letter number so and so dated 1st of April 2025. First of, as per the instruction, he has received, the concerned DAG number 214, where the petitioner's father and uncle who were Kacha Katiyan holder was made government khas land by an order dated 24/7/1982. Post of it was contended that the to occupy government khas land. And as per the Assam So-and-so Tenancy Act. What is the full form of the Tenancy Act?
My lord, Assam.
Something
Assam
1970,
Temporary
Tenancy Act,
Settlement Area Tenancy Act,
1971. A riot must have agricultural activity on the occupied land. But in the case of the petitioner, in the case in hand, no agricultural activity on the government land has been found since long. And as such, there is no question of giving compensation against the land. Post of it is further mentioned that on scrutiny of the second RS Jamabandi of the Moja, it appears that as per order dated 21/1/1981 and 18/1/1982 of the Additional Deputy Commissioner Kachar, and as per instruction of the Sub-Deputy Collector Sonai, dated 9/6/1982, total land measuring 1199 bighas, 18 kathas, 12 chataks of Dag number 79 to 145 and Dag number 173 to 223 pertaining to Patta number 1 of Moja, Sotamanda Cha Bagisa, had been converted to government khas lands. Full stop. Para. Mr. Rochuri, Land Council for the petitioner, shall furnish documentary evidence as regards occupation of the petitioners of the plot of land measuring 4 bighas, as contained in the writ petition on the next date of listing. Place the case on Wednesday. The earlier interim order passed on 19/3/2025 shall continue till then.
God bless.
This is one more instruction or what?
No, my lord, this is what.
Oh, you take back. I'm extending the interim order. You
My
argue.
lord, I am obliged. I'm going down my head.
এই কাগজখন দি দিব কাগজখন you need the copy. You have the copy.
I have a copy of it.
Can I make one small submission, my lord? In the meantime, if I am placing the document, they can also provide the affidavit, my lord, by Wednesday. They can also-
I think not possible.
Substantial distance.
You can get it extended interim order.
My lord, okay.
May I please your lordship?
Yes,
Because his non-receipt of the application for land sale permission, they went up to the office of chief minister, my lord. Your lordship asked for instruction, my lord. The seller is my lord 85-year-old, my lord. We are very anxious. Anything may
Yes.
happen at any time, my lord. Lordship was pleased to short short date.
Yes, standing as a revenue. No instruction. He is saying that he is saying that the petitioner number 1 is a senior person, 84 years. That is why.
And suffering from serious illness, my lord.
And who has refused?
My lord,
District Registrar.
Deputy Commissioner Office, my lord. No, my lord. So the chief minister prayer is submitted, my lord, but till not response, my lord. Twice submitted.
Yes, Mr. Borua, you also should take instruction from the Deputy Commissioner.
Our communication is done.
None.
Let it be.
We'll put it on Wednesday again then. Heard Mr. A.K. Talukdar, Learned Council Board of Petitioner, G. Hazarika, Learned Standing Council, Revenue and Disaster Management Department for Respondent 1. And as Borua, Learned Junior Government Board Assam for Respondent 2, 3, and 4. First of both M.S. Hazarika and Mr. Borua have sought for listing of the case on Wednesday to obtain instruction as regards the region to refuse acceptance of the application submitted by the pair sought to be submitted by the petitioner for land sale permission. Only is the case on Wednesday.
Okay, can it be on Friday? Then
It will be too near to the vacation perhaps.
let it be on when?
Not, okay, motion there, right? Motion there too. 10th.
Item 8.
Yes. Yes, Mrs. Sharma.
Lordship, we have received an instruction whereby it is stated that there is no such.
We had a glimpse. We had a glimpse in the morning. What to do?
In that case, Lordship,
Want to proceed, but not in this manner.
Lordship. That is Lordship. By following the due procedure, by.
You have to put them on notice.
By quashing this, thereafter.
You are at
Lordship,
liberty.
They may proceed by issuing.
You
them a
put them
notice.
on notice, give them effective
Yes.
opportunity to respond
Yes,
thereafter. Personal hearing and thereafter whatever
Yes.
you order you want to pass on merit.
That may be reflected.
Definitely.
And your Lordship may keep
Lord,
this.
I have only one request. A suggestion as to the next steps that the deputy commissioner may take may not feature in your lordship's order because then it will unnecessarily influence the decision that.
We
is
are
made.
we are at the motion stage only. We are at the motion stage and so many.
I leave it.
So many questions are involved. We do not want to prejudice any of the parties.
I'm grateful.
Because if we go on this, deciding this, which has an impact in the civil suits also between you,
Yes.
between other parties. So we do not want to impact all those.
I'm grateful.
It should not have any bearing on all
I'm
those,
grateful.
right? Then otherwise, this may be kept in abeyance. We can issue notice. Choice is yours.
I leave it to your lordship.
No, it
That
is.
would be better, Lordship, as, no, regarding not issuance of notice, Lordship, disposing of this matter by quashing the order of the deputy.
Because two things are there. I have to also observe that
May I?
that
May I make a
well,
suggestion?
any action on the part of the deputy commissioner or whatever district commissioner should be strictly in accordance with the principles of natural justice,
I'm great. I'm
right?
great. That may be
And
important.
providing proper and effective opportunity.
I'm
That's all. That
Lordship,
is strict. That is only.
This instruction is a part of the record.
And on the report, he can submit report. This
Lord, the difficulty is.
you can make this what do you say?
But the reason why I have impugned.
Report of respond number 4.
Yes, the
You
reason.
can
that-
challenge in criminal proceedings.
The reason that I've impugned this report is the last line, lordship may have a look at it. It is at page 50. Everything else, the first paragraph, I can understand it is a factual portion. Page 50, your lordship.
50.
Yes. It's the last line which I have an issue with. So the deed in question is seen to fake. Now, when a sub-registrar is.
He is respond number 4.
He is respondent number 4. When a sub-registrar is registering these deeds, at the time of mutation has issued confirmation reports of the registration on the basis of which the mutation has happened. For him to then.
Mr.
send
Chai,
us-
you have another ground open thereafter on Putapur. A statutory authority acting. If I comment now, it will be difficult. How can we then set aside this?
My lord, may then I'll be.
Because
grateful-
there is difficulty. There is an internal report.
It is an internal report, though it
This
has
has
been
not
placed-
taken public color.
but it has been placed on record in the title suit pending between the parties.
That is, we are not into that.
I have not taken this document out from any file. That is all I'm submitting.
But so
to
far
your
as
lordship.
order is concerned, this order pays 51. You can either.
I appreciate what is
Right.
falling from your
And
lordship.
some observations made here and there, we are not going to.
I appreciate what is
all
falling from your lordship.
interfere with those.
If-
People are
I-
people are free to make opinions. Ultimately, the culmination in the form of an order, that is the order which can be touched upon. He may give every opinion. That page 51, we are not interfering.
Lordship, page 51 is the.
No, page 50, I'm sorry.
However, page 52 and 53, 52, 53, 54. Which is the typed copy of the.
Any consequential action on the basis of that order,
There is only one consequential action. which has been-
any consequential action, if this
Lordship
goes,
is-
every consequential action goes.
Lordship may specify the Jamabandi because that has
No,
been
any
specifically.
consequential action, sir.
I'm
Here
getting-
apparently, Lordship, the mutation order was cancelled without giving him the opportunity. of
That's
getting-
all.
Then that is the violation of the natural justice. So your Lordship is going to set aside that part, and if your Lordship directs us that we can proceed in accordance with law, we can proceed, Lordship.
If the district commissioner desires to proceed,
Lordship, we can
then he can proceed, but strictly observing the principles of natural justice and giving proper and effective opportunity to the petition.
The consequential action that I was aggrieved by, Lordship may just have a look at that. It is at page 54. The
Make
top
an
portion.
application, if the foundation falls, the superstructure falls. But Mr. Will observe, Ihsan Saya, Land Council Board of Petitioner, G. Hazarika, Land Standing Council, Revenue and Disaster Management Department for the response number 1, and Mr. H. Sharma, Land Additional Senior Government Advocate Assam for the response number 2, 3, and 4. First of Land Council for the parties have advanced contentions on a number of points, on a number of issues. Also, after extensive hearing, the Land Council for the parties have the submissions of the Land Council for the parties have centered on an order dated the order dated 8/3/2024, passed by the District Commissioner, Kamrup Metropolitan District, Guwahati. Within bracket, the respondent number. Two. Post opera, impugned in this writ petition. Along with an order dated 12/12/2023 bearing KRN number 11/2023 issued by the respondent number 4. First of para. The order, impugned order dated 8/3/2024. Page 51 reads as under. Para. From the impugned order, it is discernible that by the order, two orders two mutation orders within bracket Roman 1 MET/GUW /2021-2022 /50809 OMUT dated 2010-2002 and Roman 2. RTPS dash OMUT stroke 2022 stroke 50502 within bracket 71387 file over stroke 2020-2023 stroke OMUT bracket close. Any date you have?
Lord, it would be.
Have been passed earlier in favor of the petitioner have been set aside.
It would be 16 June 2020.
Have been cancelled. Cancelled. No, no, sorry. Have been directed to be cancelled. Full stop. The direction has been made by the respondent number 2 to the respondent number 3 to affect the cancellation. Full stop. Para. One of the principal grounds of challenge to the impugn order dated 8/3/2024 is that the impugn order has been passed behind the back of the petitioner in complete violation of the principles of natural justice. Full stop. It is a case of the petitioner that the petitioner was never put to notice prior to the impugn order dated 8/3/2024. Full stop. Para. When the writ petition was listed on 21/3/2025, the Learned State Council was requested to obtain instructions in writing from the respondent number 2 whether before passing the order dated 8/3/2024, the petitioner was put on any kind of notice or not. Full stop. Para. Mr. Sharma, Additional Senior Government Advocate, Assam, has submitted that he has received instructions in the form of an office letter number so-and-so dated 2/4/2025 from the respondent number 2. Full stop. Tracing a copy of the office letter number so-and-so dated so-and-so, Mr. Sharma has fairly submitted that before passing the order, impugn order dated so-and-so, the petitioner was not served with
First page, last line.
Yes. Was not served with any notice. Full stop. From perusal of the impugn order, from a mere look at the impugn order dated so-and-so, it is evident that the impugn order is like due to the impugn order, the petitioner is likely to be visited with adverse civil consequences. First of it is to settle proposition of law that any order which is passed, which is passed, any order passed against a person which brings civil consequences to him, must be passed in following the principles of natural justice. So the principles of natural justice demand that the person who is likely to visit with civil and adverse consequences must be put on prior notice so as to represent his case as to why the order likely to be passed should not be passed against him, and such a person should be provided with a proper and effective opportunity of being heard Full stop. On that count, comma, the impugn order dated so and so does not stand the scrutiny of law, and it is accordingly set aside and quashed. Full stop. It is made clear that the impugn order dated so and so has been set aside and quashed on the ground of violation of the principles of natural justice. It is further made clear that any consequential action taken on the basis of the impugn order dated so and so will have the same bearing. Full stop.
My lord, may-
Will have the same bearing.
I appreciate, but my lord may kindly mention, including that taken on 29th of March 2024, I have attached the action, consequential action. Page 52. Because a new RTR number has been opened by the circle officer pursuant to the deputy commissioner's order.
Which one?
Page 52, your lordship has?
That consequential, I think lordship, that order will include all this.
I am only requesting that your lordship record including this.
Which part?
My lord,
Page 52, serial number 4.
my lord, the action taken
Okay.
Last-
on
last
29th.
line.
Yes.
Any consequential action regarding in respect of the records of rights. Shall have the same bearing. Records of right, right?
This is the
Jamabandi.
record.
Within bracket Jamabandi. Absolutely. It is made clear that in the event the respondent number 2 decides to proceed FRIS, then the respondent number 2 shall follow the principles of natural justice and by putting the petitioner on prior notice and by providing proper and effective opportunity of being heard and to present the case of the petitioner before the respondent number 2. Present her case. Lady, right?
Yes, sir.
Lady.
Yes,
Lady.
sir.
Okay, and present her case. Person. With the repetition is allowed to the extent indicated above.
Much
There shall be
appreciated.
no order as to first. The copy of the office letter being number so and so, dated so and so, raised by Mr. Sharma is kept with the case records, marking it as document X.
I'm great.
Item number 10.
Yes, sir. This is under what act?
GMD.
Can be done or not done? Can it be done by in that manner?
Which manner?
Yes, you are supposed to obtain instruction.
Lordship, so far as my instruction is concerned, one demolition order is against the mother, one against the daughter.
Daughter.
So far as the daughter is concerned, Lordship, some portion she has already demolished, and thereafter she is paying for time one again and again. So complete demolition has not yet taken place. So this is a case, Lordship, where the mother is before your honor. So I am not objecting much, Lordship. Lordship will pass a similar order. But only one point I am trying to
Yes,
point out.
yes, GMD Act.
If this point, section 26 is only the appellate provision in the JMDA Act. Whether this appellate provision applies in case of an order passed under section 88 on. That question Lordship will
To decide.
decide in.
Which
an
one?
appropriate case law.
Phase, section
Section 26.
26.
That is the only appellate provision in this act.
Huh? Come to section 71.
71 is the Constitution Act.
Huh?
Constitution of. the-
Appointment of appellate authority.
To hear all appeals
All appeals.
arising out of the provisions of this act. Is it not all pervasive?
Even of this state government.
71, section 71. If I
All
am not
appeals.
wrong,
Lordship, appellate provision only one Lordship, that is section 26.
no.
And it specifically states that it is an appeal against section 25, an order passed against.
Huh?
In terms of section 25. So at this.
No,
point,
no.
Today Lordship.
See, let us read together then.
Yes.
Any applicant aggrieved by an order. This is an order under what?
88.
The impugn order is under what?
88.
88. What is the so-called notice?
So-called notice on page
90? Or what?
87. Type copy.
Eighty-seven.
Against Nabolita Golita, respondent number 8. And
No,
my one-
86, 86. 86?
Yes, only.
86? Is it 86?
87, Your Honor.
No, not 87. 87 is something else. Nobonita Kolita.
Yes, only.
You are Putul Kolita.
Yes, Your Honor.
Then 86.
86.
Yes, only. Purul Golita. 86, only.
Notification. Notification from the notification from the report for us. For ICMDA notification, DMDA notification from the
Municipal Corporation.
'71 is general. Now let us see 25 or 26 as contended by you.
71 states, okay, to hear All appeals.
All appeals.
Arising
Okay,
out
now
of
let us see.
what that lordship,
Ah.
there has to be provision
Okay, let us see.
out of the provisions of this.
Right.
And the only appellate provision is 26.
Even it's even it's. Even accept.
26.
Just submitting, I am also, have not formed any form opinion on this now. Lordship will decide this on in an appropriate case. But why I am submitting this lordship, if your lordship remembers the judgment lordship, direction in the matter of demolition of structure at the lordship of the direction. There are, if lordship goes to D1, small Roman 1, their lordship will find one statement, or even if it does not show, lordship, even if appeal provision is not
That,
there.
that I am aware regarding
So there
redemolition.
may be a situation, lordship, there may not be an appeal provision, appellate provision against the demolition order. But that may be also a situation.
Because this is this will be an order of the original authority, right? This order of demolition will be an order of the original authority. If there is no provision for appeal, then we have to read this redemolition order by the Supreme Court.
That is why this 15 days time was granted. As appeal provision is, even if appeal provision is not there, you have to give the party a 15 days minimum time.
Save as otherwise provided state on a select to get all the pieces riding out of the.
It's 9. You said about 90 days, Mr. Nayak, during the previous.
Yes, in the subsequent judgment.
Okay,
Appeal.
clause Roman 9.
Appeal is to be decided within 90 days.
Mhm.
In the event of any application appeal. Not importantly, in this case, the doctor has filed a review also. That was also decided by the JMT authority, rejected.
Okay,
A review was filed. Under which provision I am not able, but a review was filed.
okay.
It was also decided by the.
Yes, sir.
So in this case, Lordship, I am not objecting. Lordship may dispose of this matter in terms of professional background, Lordship. But in an appropriate case, I am saying.
Okay.
When there will be a situation, Lordship. Lordship will definitely
Okay.
take point of this.
Huh?
Today, Lordship
Ah.
may pass this order as if I have not wanted this.
Okay, then you prefer appeal in the event, I'll pass this order after going through.
Yeah.
The other matters are there.
Yeah.
So, this, against this, impugn order
Yeah.
of demolition,
Your Honor.
that is 14/6/2024.
Your Honor.
Since you are a senior citizen,
Your Honor.
right?
So I've got the benefit.
So, for that benefit should be extended and for 1 month.
Yes. Only no coercive action here.
No coercive
No
action
action.
in terms of that,
Yes, Your Honor.
right?
Yes.
Thereafter, the district judge will take
Mm.
the application for condonation of delay on its own merits.
Okay, Your Honor.
Right?
Okay.
Right, Mr. Nayak?
Yes, no.
One more
He
thing, Your
will
Honor.
take the call.
Here,
One more thing I want to draw your attention, Your Honor. That the permission NOC given to Nabanita Kalita 27/12/2004. It don't have any validity, Your Honor, because it is time bar.
Mr. Counsel, you are concerned with your own demolition.
Your Honor, but the damage has been done because of the.
You are inside a glass house.
Yes, Your Honor, I know that.
Right. And that lady is also, your daughter is also in a glass house. Now, staying in a glass house, don't throw a stone to the other's glass house. You try to save your own glass house.
Your Honor, my belief. Okay.
So you put a challenge to that. You are here against the demolition order passed against your house, right?
Yes, Your Honor.
Right?
Yes, Your Honor.
Then let us confine to it.
Mm.
I am trying to give you a protection.
Yes. Oblige, highly
So
oblige.
that you can lead evidence that yes, at that time there was no permission, all this you can avail.
Okay.
Here we are concerned with certiorari jurisdiction.
Much oblige, sir. Much
That
oblige.
judge authority will be having the appellate jurisdiction. The scope will be broader for you.
Yes, Your Honor. Thank you. Thank you.
Here you are preceded with notice.
Yes.
Your reply, rejection, demolition.
Oblige.
Will pass the order. 1 month. Within 1 month, you file an appeal. Being a senior citizen of 75 years, so I am giving you this. And we'll also observe that the district judge will also consider that aspect, seniority.
Okay.
Madam, you are there. Okay. It was Mr. Passport order. Oh, okay. Okay, 1 minute. Mr. W. Raja.
Yes.
Petitioner P. Nayak, standing also GMDA for 1, 2, 3, 4, and 6. MSS Borwal and Junior Government Advocate Assam for Asman number 5. I will get over for the passport.
Oblige.
Item number 23.
Maybe tomorrow. Or I will be disposed of. So cause notice is missing.
Yes, for their statement that they have not received. That is their statement. I'll make it. I'll obtain instruction.
You are saying so cause notice is missing. I think you did not visit the portal.
Because my lord, he is not my lord.
I have seen at least 200 cases till now. Everybody is annexing so cause notice. You are the only exception.
In terms of other orders, my lord.
No, cannot be. Okay, you take instruction. When? Result you know, but procedure is to be followed.
When order no gun.
When?
After 10 days.
10 days. You go after Bihu then.
Second.
Or you can provide the show cause notice from the portal, we can dispose of. Mr. Kyle will take 10 days.
Well, before Bihu, my lord. Let's try before Bihu.
Okay, try on Monday or Wednesday.
You can file. If he is your.
If you get the show cause notice from the portal, download and annex it. Okay. All right, Mr. A. Conical Land Council for the petitioner. And Mr. S. C. Kyle and Standing Council CGST for all the respondents. On the prayer of Mr. A. Conical Land Council for the petition is the case on Wednesday. There is another case I have posted tomorrow to dispose of.
Item 60.
60.
Lordship, standing counsel for APGCL.
APGCL? Yes. What do you say about this?
Okay, just now.
When do you want them? You take instruction in the meantime.
Lordship.
Monday.
Firstly, it is on
I understand. That is why I am giving you time. Right. Get your instruction on Monday. By the time wall will be complete.
Lordship, yes.
There will be no ingress and egress to their plots of land.
It is a
Monday.
limited pay. We are not against the wall, Lordship.
Right.
Yes.
I'll put you a hole. Miss Sir?
US Bora.
US Bora, Planet Council for the petitioner is present. Miss
name of Dina may be
Miss
Mr. Dina.
D. Nath. Mr. D. Nath is the standing counsel. Okay. Miss Ann Borman, Planet Council, representing Mr. D. Nath. Planet Standing Council, Assam. Power Generation Corporation Limited. APGCL has submitted that the copy of the writ petition has not been furnished earlier. Post of Mr. Boral and Council for the petitioners will furnish a copy of the writ petition along with an annexure to Ms. So and so. By today?
Lordship today.
Post of as sought for by Ms. So and so on behalf of Mr. Nath and Standing Council APGCL is the case on Monday. Post of the name of Mr. D. Nath, Standing Council APGCL be reflected in the respondent in the call list. Tuesday? Okay, motion. Okay. Tuesday.
Lordship.
Motion there.
For independent party, item number 26.
Yes, whom do you want?
My lord, opposite party number 6 may be, my lord, implicated as a.
Hard. Why?
My lord, what happened, my lord, the government advocate has submitted before the court that the land was acquired for the PWD and as well as, my lord, National Highways and Infrastructure.
And how you aggrieved?
Now.
Your land has been acquired.
Yes, my.
Okay, hard. Mr. Goswami and Hawk, Learned Council for the applicants. Any CGC? Miss S. Burua, Learned Central Government Council for the opposite party number 1. Pierre Mohanto, Revenue 2.
About 3.
And Goswami.
For 3.
4-3. None has appeared. For the opposite party number 4 and 5 today on call. Post op. The applicants as the writ petitioners has preferred the connected writ petition WPC number 4746/2023.
In para 5, I have explained my space 6.
why we have filed this.
stating that the petitioner's parcels of land situated in village Damra Patpara and Nakmakundi, Dudnoy Revenue Circle have come under the purview of land acquisition in land acquisition case number 13/2011-2012. Full stop. It is stated that the land acquisition, the process of land acquisition has been undertaken for widening the national highway number from widening a national highway from Damra and Dainadubi. Full stop. The applicants have stated that the land acquisition process, the national highway project has been undertaken by the Public Works Department National Highway, within bracket Assam, and the National Highway and Highways and Infrastructure Development Corporation, within bracket NHIDCL. Full stop. The instant interlocutory applications has been preferred seeking implement of the following number 6 to DDO. As party response number 6 in the connected lead petition. First, I have gone through the statement and affirmations made in this interlocutory application, seeking implement of the aforementioned party respondent. First of having gone through the same, I am of the view on this court is of the considered view that the proposed party respondent is a necessary party for adjudication of the issues involved in the connected lead petition. First of the learned counsel for the opposite parties have submitted that they have no objection if the interlocutory applications for implement is allowed. Accordingly, one instant interlocutory applications stands allowed. The learned counsel for the opposite party, applicants dash lead petitioners shall file an amended cost title to the in terms of the notification dated so and so within 3 working days from today, and in the event of such submission, you are asked to carry out the necessary corrections in the case records as well as in the SAS. Thereafter is the case for admission for issuance of notice to the newly implemented party response number 6.
National Highway 217. National Highway 217. 217.
217.
Item 27 for admission.
Lordship. My lord, this petition has been filed by the petitioner who pronounced Talake Hassan.
Oh, very critical for me. I don't know. Very complex for me.
You'll understand. Talake Hassan means pronouncement of 3 talaks in 3 months or 3 ministration period. That is called Talake Hassan. So this is supported by the Muslim laws 1935, which was repealed recently by the government of Assam. But the case has been started or the talaks have been pronounced before repealment of that.
There is a saving clause or not?
Yes.
Savings clause is there. Here it is already.
Saving clause is there.
Actually, this has come into effect on 16/3/24.
What is the issue here?
Issue is that after pronouncement of 3 talaks, the said shall be communicated to the registrar, local Muslim marriage and registrar, who is the Qazi. But the Qazi Act has been also abolished. In that view, the now present registrar is the district commissioner. So, as the Act has been
That MMR is no longer there.
Lord?
Earlier MMR
That is not there.
is not there.
Not there. But it has come on 16/3/24, and my case was communicated to the district register on 24/6/23. So much earlier than the repealment of the act.
Earlier, who used to register?
That Kazi, Muslim Kazi.
MMR,
Kazi and register.
Muslim Marriage Register,
Muslim marriage register come Kazi.
under the 35 Act.
Yes, under the 35.
Then when it was abolished,
It was abolished on 16/3/24.
16/3
When it was
2000.
published in Extraordinary Gazette.
Okay.
So before that,
Then who has stepped into his shoes?
husband.
No. MMR is gone.
Yes. MMR is gone.
He's gone.
Yes.
So along with abolition, his post is also gone.
Yes.
But according to you, proceeding is alive.
Proceeding alive.
Now who has stepped into his shoes?
Sub-register, that means district register and his subordinate officer.
Okay. And they are not doing anything.
They are not doing anything.
Yes, Mr. Goswami.
Initially, MMR is there, Lord.
MMR is gone. According to the Council for the Petitioner, district register has entered into the shoes of the MMR.
Yes. This is the repeal.
Okay.
Repealing clause is also there.
Both of you have the act. I don't have the act. Tell me now from the act. If the proceedings are saved
Yes.
by the repealing provision, if there is repealing provision,
Yes. Yes. This is there.
maybe there will be subsection 2.
Yes.
Is it not?
Yes. Option 2.
All proceedings, is it there?
Which are earlier taken,
Huh?
that are alive.
Huh?
And that should be that should be treated as earlier.
Huh?
As earlier. So now the place of
Yes.
MMR has been taken by district commissioner, district register.
He has to approach district commissioner.
District Commissioner, somebody is filing affidavits.
Kazi.
Oh, Kazi.
Kazi says that as I am no longer Kazi, so I have
Okay.
to-
He says,
Yes.
my shoe has been taken away. Then,
He has to approach.
I think you are a party,
Yes.
is it not? You are a party, response number 2. Get his comments. How he is thinking to to proceed with the matter. Let him take instruction and you are.
He is all that. He will
Give me the act.
register. He will register the divorce in the district.
Give it the act, just.
নতুন না পুরো?
কিতাপ আকারে ওলাইছে
Just repealing it.
কিতাপ আকারে ওলাইছে নেকি নেকি নহলে এখন ডাউনলোড কৰি থৈ দিব লাগিব
35. Net মানে এটা relevant version এইটো আহিছে।
I think virus is challenged or what?
Virus not a challenge because the problems have been addressed by the present act also, but it has become some difficulty. But that is, after all, it is curable.
Date of commencement shall be deemed to have been validated.
And this is the new act.
Where this previous MMR is saying something?
MMR says as per rules 27,
No.
I have to inquire, but I have not that power.
No. Where from? You are saying that previous MMR
Yes.
has acted on,
Has not acted.
has not acted.
Has not acted in view of section 9. Section 9 and 10B.
When did you approach him?
I have approached him on 24/6/23.
24/6/2023.
Yes.
When the act was repealed,
That is
16 March.
that is repealed 16 March, but it has come, the new act has come into effect on 16/3/24.
No, repealing act. 16 March. Okay. Repealing, along with the repealing act, act has come.
Yes. It is published in Gazette, that is I have given.
So you approached the MMR, earlier MMR when?
16.3.
Where from we can find out?
That lordship may kindly see page 17 of the writ petition. Annexure 4.
Okay, Mr. Take your instruction from the heart, Mr. As per the new act, district register.
Yes, it is.
Heart.
No,
Yes.
that things should be done by the sub-register.
Okay.
My lord, may I pray one thing, my lord? Instead of keeping the matter pyramid CRPF, I am posted to various parts of the country. Now I am in Jharkhand. So lordship may kindly dispose of the matter directing the district register to act as per the provisions of law.
No, first let me find out whether it is a proceeding pending or not.
It is the case of
Because
2023.
see, all your documents have been submitted before the MMR.
Yeah.
Whether to be proceeding
No,
pending.
I have also submitted to them also. They have also
Let it
23 case. Now we are in
You are
20
you are in hurry, some hurry. It appears you are in hurry. Date is fixed. Heard Mr. M.U. Mahmood, Learned Counsel for the petitioner, Ms. G. Hazarika, Learned Study Council Revenue for the response number 1. Mr. Gangusami, Learned Junior Assam for the response number 2. Anybody earlier appeared for response number 3? Huh? Sodar Kaji? No, he is no longer there now. And anybody for response number 4, Mr. Mahmood?
My lord, no, notice was served, notice was sent, but through justice service, but she refused that an affidavit we have furnished.
Okay. Mr. Mahmood, Learned Counsel for the petitioner, has submitted after a repeal of the Assam Muslim Marriages and Divorces Registration Act 1935 by the an repealing act, a new act. What is the name of the act?
Name of the new act is the Assam Compulsory Registration of Muslim Marriages and Divorces Bill.
Not bill, act. The name of the act.
Yes, only bill act.
Has come into
It has
effect.
been replaced by act.
It would be a repealing act on WEF 16/3/2024.
Of the Gazette notification is of 25th October 2024.
Okay. Which was published in the Assam Gazette on?
25th October 2024.
Okay. By subsection 2 of section, it is stated that by subsection 2 of section 2 of the repealing act, notwithstanding such a repeal of the act, anything done or any action taken under the Assam Muslim Marriage and Divorces Registration Act 1935, before the date of commencement of the repealing act, shall be deemed to have been validly done or taken under the repealed act. First off, there is a case of the petitioner that after completing the formalities of Talaq-e-Hasan, the petitioner submitted the records before the erstwhile Sodar Kazi and Register of Muslim Marriage and Divorce within bracket the response number 3 on
24/6/2023.
So it is his contention that with the enactment with the, by virtue of the, by virtue of section 2, within bracket 2 of the repealing act, it is a deputy district registrar and the sub registrar
Yes.
who have to proceed with the proceedings earlier pending with the erstwhile MMR. Erstwhile কি কৈছিল পুরা নামটো কিবা আছিল ন so and so Mr. Goswami, Learned Junior Government Advocate, some appearing for respondent number 2 shall obtain instruction and file affidavit as regards the steps taken by the respondent number 2 to proceed the matter to proceed with the matter. Yes, when? 2 weeks? Okay. They'll be busy with Panchayat after 3 weeks. As sought for by Mr. Goswami, Learned Counsel for the and so, release the case after 3 weeks. In the week commencing from 13th of May. How like?
28.
You need copy of this repealing act.
Item 28.
We retain this. Yes, sir. We have to fix the date, man.
8th of
Please
May, my lord.
enjoy you thereafter.
Yes. Learned May will come on 8th of May, my lord.
8th of May. He is fixing too many matters on 8.
No, 8 and 9.
Okay, be doctor. Doctor is for petitioner.
My
Senior counsel. It's said by Mr. Zedas. And counsel for petition, G.N. Sahwala, and senior counsel. It's said by Miss.
Yes.
For the respondent number 5. S.S. Roy. You are CGC or state? Okay. The counsel for the respondent number 2, 3, and 4. 2 and 3. And Goswami, Learned Junior Government Advocate Assam for the respondent number 1 and 4. Okay, are present. As sought for by the Learned Counsel for the parties, this is the case on 8/5. Okay, the interim order passed. Continue.
Item number 29.
Somewhat cartoon. Cartoon and another Haji. What kind of petition?
My lord,
Private respondent?
private respondent.
Respondent number 1.
My lord, let the matter come after view vacation. My lord, regarding my lord, the maintainability lordships, my lord, that was in view of the order passed in a recent case, my lord. 422, no. this is,
Yes.
My lord, but-
227.
Yes, but the earlier case, my lord, that was also filed in view of the lordships order.
I became wiser
Yes, my lord.
with time.
Yes, my lord. But at that time, tribunal was not constituted. Because of that, my lord, this petition was filed. So if it is tribunal is considered, that can be referred, well, that will be referred, my lord. This is my.
So after view.
After view, my lord.
I think you are, it is clear that you can file 227
Yes, my lord.
and time spent because I think that is a special, he is a court.
Yes,
He is a court.
yes.
So limitation act will be applicable and plus that section 14 for pursuing proceeding
Yes, sir.
before another forum.
Yes, sir.
I think that will be
Yes.
permissible. It is up to you. Why you are delaying it then?
No, at that time, my lord, there was no tribunal. That is why, my lord, lordships, my lord, one order and a lordship.
No, it is special tribunal only.
Yes, my special tribunal, my lordship was passed one order and another, my lord, order that is passed by the Honorable Justice, my lord, Ujjwal Bhuya, my lord. And that basis, my lord, the case was, my lord, admitted. So, my lord, now, my prayer, my lord, in the recent development has occurred because the tribunal has been constituted. So, that.
Tribunal constituted.
My lord, as party, my lord.
Let us see.
Wherever order, my lord, this I have seen, probably tribunal has been constituted, my lord. That is why I have to, my lord, clearly.
Let us, if that is, let us see the document. Any idea?
No, my document is not there, my lord. So I have to confirm whether tribunal is there or not because the lordship has
think
passed
no.
the recent order that is in 558 of 2024. Where, my lord, these things.
227 is
Yes, my lord.
maintainable.
Yes, my lord.
But I myself asked the appropriate authorities, why you are not constituting?
That may be, my lord.
I don't think there is appellate tribunal as on date. Okay, on the prayer of Mr. P. Mohanty, learned counsel for the petition, the matter stands adjourned for a period of 2 weeks.
Item 30,
Grameen Vikas Bank. EGP. Complete their respective instructions.
So that insurance amount, your
Huh?
lordship, not the, we have made a claim for the death insurance of the wife of the
Investigation has
petitioner.
not processed a claim for an amount, date of his wife, Pradhan Mantri Jiban Jyoti Bima Yojan. Now what they say?
So
Bank?
they are saying some discrepancy in the documents because the death certificate which was originally obtained, it was in the nickname was obtained. Subsequently, we have made a correction and was submitted, but they are not, insurance not been providing that.
Ah.
And the that about your lordship.
What
bank
is
has-
death certificate? Let us see.
See the-
You earlier approached this court or what?
Lordship.
What is the direction there?
No, lordship, that was written because it was applies to obtain a death certificate on the same registration in the correct name.
Death certificate, previously earlier it was issued by the authorities of so and so in a nickname of the deceased wife, Lokhimai Karki Dorji, instead of Devi Maya Dorji, and is obtained a new certificate on so and so with the same registration number with the authority of registration mark. In the actual name of his wife, Maya Rani so and so, he has decided to approach who is the appropriate authority?
LIC.
Hmm?
Lordship, LIC.
You are LIC?
Yes.
Okay, LIC. Ah.
Honorable Court directed to take the instruction from the concerned authority. So I have taken the instruction and I'm going to submit the Prime Minister is going to please Bima. And here claiming the
Bit louder, sir.
document how to settle the claim.
Show it to him. Claim may be considered. But we have the mismatch in the name of life is your late Devi Maya Dorji. Does not allow payment of the claim as per the rule of the corporation. However, yes, how it is can be resolved.
It's this earlier it is on the LICI issued a letter to the bank.
Huh.
Coming as well.
Huh.
Some documents of which are submitted by the petitioner to the bank, but without verification of the document, forward the document to the LIC. And LICI scrutinized all documents and found some anomalies in the document. So the letter dated here one.
Oh, what is to be done?
So here, bank, if the bank is scrutinized or verify the document and check the.
Which bank?
Lordship, bank has already filed a that has already been sent to the LIC subsequently, Lordship.
No,
After withdrawal of the.
Who is bank here? Who is appearing for a bank?
Mr. Ganguly was appeared, your Lordship.
Ganguly. Ganguly means.
Mr. A. Ganguly.
Huh?
A.
PC. Oh, he has leg fracture.
An affidavit also filed. with the-
Today morning he appeared through PC, I think. Huh? Then he should, I think his name is appearing.
Lordship.
It is question linked. Oh, he informed today morning that question linked. Oh. Okay, he is there through PC perhaps. Kitya nahi? Oh. Disconnection, Mr. Mohan.
Lordship.
Ganguly. His presence can resolve the matter.
Lordship, already.
LIC wants documents, some kind of say certificate regarding Devi
Devi Maya
Dorji. See this document, what they are saying.
Let him provide your lordship.
This is not a basically lease. It is to be decided as per with a mutual agreement.
Already bank, after that, your lordship, we have already obtained in the original name of the petitioner.
No,
death
first it
certificate.
is death certificate.
It was obtained and it was submitted to the bank. Bank has already forwarded to them, your lordship, subsequently, your lordship.
Yes, sir.
These are forwarded but not verified, the documents. Documents are not verified to the bank.
Let Mr. Ganguly appear on some other date then.
Lordship. Any
Third,
chapter
Mr. L. Mohan, learned counsel for the petitioner, and Mr. A. L. Mondal, learned counsel for the respondent LIC authorities. Mr. A. Ganguly, learned counsel for the respondent AZB Bank, is not present today. Mr. Mondal has submitted that for consideration of the claim, the concerned bank has to provide an undertaking that the discrepancy in the identity of the deceased assured is incorrect. And it has to further undertake that the identity as genuine and hence payable by the LICI poster. Mr. Mondal has submitted on the basis of a letter dated 5/2/2025 issued to him by the manager LICI Guwahati. Mondal Ganguly is there. Okay. List the case after the vacation only then on so and so date.
28.
Mr. Ganguly as counsel for the respondent AZB Bank shall obtain instruction in the matter.
Lordship, there is an affidavit filed by the respondent bank, your lordship. It was received on 11/2/2025. That may be called for you. This is probably not in the record. Your lordship.
Mr. Mohan has further submitted that an affidavit in opposition of the respondent has been filed by the respondent number 2.
Respondent 1, 2, 3, and 4.
1, 2, 4. And the said affidavit in opposition is not tagged with the case record. So the office should trace out the same and thereafter tag the same with the case records. Trace out the said edition affidavit. Huh? Sorry, affidavit.
Item 31.
Meet, please, your lordship.
Yes.
Lordship, so far the last order, the panchayat was about to file their affidavit, but they have not submitted till date, your lordship. PNR.
Last day you made a prayer.
Yes, it
for
was for
adjournment.
adjournment. But they sought some time to file affidavit.
Circle officer was direct.
Cycle officer was a directive.
Circle officer already made a statement that no.
Made a statement.
So we were directed to bring instruction, and we have already got it.
What is the case about?
Case is that, your lordship.
The case is their bona fide settlement of the plot of land measuring swings are covered by swings and What instruction you obtained, Mr. Kumar?
So Lordship, you have got the section regarding, your Lordship, there, our land is defined land. From the-
Your land is different land.
Yes, sir.
No, who has evicted them?
Circle office.
Circle officer.
Revenue
And
circle.
according to the last instruction, if I have understood correctly,
notice was
petitioner's name are found in an annual patta. They are annual patta holder.
Your Lordship,
If the affidavits are not filed, picture will not be clear. And yes, Mr. Towler, you are for whom?
I have not responded number 6.
Oh, how you have come in? Why? Who are you otherwise? President?
Yes.
Okay. Yes, both of you file your affidavit. Then only picture will be clear. On the basis of instruction, position will be clear because they are also annual patta holder. You say your land is different.
From the report we have collected from the revenue branch. It is
Sure, you
that-
file the affidavit, short affidavit, at least the picture will be clear.
Yes. Different land, pilot, different.
Oh, you file also? You file?
My position is different, but their position is different.
No, you're president. You file your affidavit. Picture will be more clear. Okay, hard, miss.
Better to file by the government members.
Okay, why don't you supplement it?
I have received the person also.
Then you have some doubts. Why? You are not filing it.
Government file.
File it, you also file it. More the merrier. Here join petitioners. Who represent whom?
I have got responsibility.
K. N. Goswami. Junior Government Advocate Assam for response number 1,
I am
2,
three.
4. Mr. K. Corner, Senior Standing Council Panchayat and Rural Development Department for response number 3. And Mr. I. A. Talukdar. 6. Land Council for response number 6. First of Mr. Goswami, Mr. Kumar, and Mr. Talukdar have all sought for and granted 3 weeks time to file
But
their
positively
respective
let them-
affidavit in opposition. 24 matters, let them come, then we'll see.
Deeply obliged.
Out of 3, 1 will file, at least Talukdar will file.
Deeply obliged.
34.
I am 34.
Salema Hussain.
My lord, this Rural Children's Education Society is a model school. And they have 2 bigha, 2 katha, 10 lessa of land.
What school? What
It's
kind of school?
a model school.
Model.
Model school, Assamese
Model,
medium.
okay.
Now, this school has got 2 bigha, 2 katha, 10 lessas of land. The school was established in the year 1991. And there are now 395 students. The result of the school in Sheba is brilliant. Now, nearby some schools, some demarcations have been taken place and they have been asked that you may be evicted. So we are also afraid of eviction. But there is the order of the government, that is, I mean DC, that Lordship may kindly see for a moment, page 36, my lord. We wrote a letter to the Deputy Commissioner that the school has been established and some land is required to be paid for 4 bighas of land from the government, that is page 36 and extra 5.
You are seeking more land or what?
4 bighas of land we first prayed. But thereafter, my lord, there is a communication page 37. From the end of the ADC, Borpeta, allotment of land in favor of RCES Model School, Khorichala Haldia Village, Gugubari. this which letter number so and so. With reference to the subject and letter cited above, I am to inform you that allotment proposal in respect of so and so school yet to be received. Therefore, you are requested to submit allotment proposal at an early date. So, this letter was written on 10/11/2016. But till today, my lord,
Yes,
allotment proposal
nobody is filing affidavit. Huh?
Now, school is in the DGR.
File your affidavit, then
that is not
whatever
correct.
is there.
We have so many orders that it is a school, not a private persons are living there.
MU Mahmood Learned Council for the petitioners. Secondary education. Yes, madam. Miss Musahari, Standing Council, Secondary Education Department, for respondent 1 and 2. 5. And Gusami. 3, 4. 6. 6. Circle officer?
Yes.
Okay. From the positions made on behalf of the petitioners, it appears that an affidavit, affidavit from the respondent number 2, 3, and 6 is necessary. Post of Mr. Gusami, Junior Government Advocate Assam, appearing for respondent number, 3, 4, and 6. 3, 4, and 6. Appearing for respondent number 3, 4, and 6 has sought for and is granted 2 weeks' time to obtain necessary instructions. And to file counterfeit with regard to the prayer made in this petition regarding allotment of 2 bighas, 2 kathas, 10 lesas of land.
Yes. As per the ADC's letter dated, ADC's letter dated 2/11/2016.
In terms of the letter dated
2/11/2016 and 10/11/2016.
Ten 11/2016. 10/11/2016 within bracket Annexure 6.
Annexure 6.
Okay.
May I pray one thing, my lord? Till then, no disturbance.
No, you need additional land, right?
DGR, they have themselves proposed. If the land is VGR, why they have proposed? Kindly consider. So these are the lamb schools.
Are you being disturbed?
Disturbance, nearby areas they are getting disturbance. So we are afraid of that. So some protection, my lord. A school, it is a school, my lord. Then why they proposed? Kindly consider.
That can be de-reserved.
Yes.
That can be de-reserved. Okay, I will fix a date. Give a date. On a particular date. We are fixing a date. Instead of 3 weeks, we are putting a date. I don't know for last 6, 7 days, no interim order has been passed.
Our impression is that the authority went for inspection and they measured the land.
Okay.
But what is the result, my learned friend? 28.
Let them file affidavit. Yes, sir.
Number 43, Roshi fix the matter last occasion, madam. The contemners, my lord, the council, my lord, they apprised before this honorable court to place the matter.
Sir, when you on Tuesday?
Tomorrow.
We are already over. On
This
Tuesday?
compensation part, person is bedridden condition, my lord. That is why, my lord, that is the urgency, my lord.
I'm putting it this
Yes.
Tuesday. Okay, B. Chetri. And who is for the respondents? Anybody appearing?
B. Gogoi is there, my lord.
Okay, the petitioner is present. This is the case on Tuesday.
Lordship.
Lordship,
Lordship,
item
item-
number 47. On last occasion, your lordship wanted to know from the corporation department whether my building is still required. Because that building is under seal for last 2-3 years, lordship. Lordship, that is why lordship fixed the date today, lordship. That must.
What to do?
Lordship,
Yes, cooperation. Required or not required? What is the instruction? Neither here nor there.
Because so that there is no evidence is not tampered. But if the court allows, it may be done if the corporation department officers are present there.
Okay. Wednesday, Mr.
I'm R Islam.
R. Islam. Learned Counsel of Petition, Mr. R.B. Goswami, Learned Counsel representing the MD Bora, Standing Counsel, Corporation Department, Post of as sought for by the Learned Counsel Board of Parties, list the case on Wednesday.
Item 44, your lordship, there is an interim order that may be continued, your lordship.
Okay. After viewed, and what is the matter?
So it is eviction matter, your lordship. Eviction, your lordship.
Huh?
Eviction.
Eviction.
Item
Okay. L. Mohan.
On behalf of their.
Item 34, similar.
Your name is there. How, why should it?
Sorry, sorry.
Item
L. Mohan, Learned Counsel of Petition is present. List the case after 3 weeks. The interim order passed shall continue till the next listing.
Similar prayer in item 34 also, lordship, interim prayer was there.
34.
Yes.
34 is not
36, 36.
36. Okay. R. Chaudhary. PK Chaudhary is there, or who?
For private respondent.
Private respondent, who is there? Okay. There is the case after 3 weeks, the interim order.
Lordship,
If interim order is there, make a prayer.
42, Lordship, item 42. 42, eviction drive will be going on, so matter may be fixed on
42.
42.
Eviction.
Eviction matter.
Notice
has already been issued, so
Ah.
agreed by that notice, case was appeared. Party. So next week, Lordship.
Next week. Not possible, sir. All this. Whether your interim prayer was considered.
No, stick instruction was given to follow Salakuddin.
On the prayer, Mr. B. Bhugan, Learned Counsel Board of Petition, is the case on Wednesday.
Item 40 pertaining to the reservation of Panchayat, your lordship. Panchayat election has been declared, your lordship. Last day nomination is 11th of April, your lordship. There is urgency.
Okay.
Tomorrow or Monday.
I don't know, Kiman Monday. Monday.
11th is last date for nomination.
Okay. Motion. Okay, Tuesday. On the prayer, Mr. Piraman. Yes.
Hello.
Item number 37. I'm paying for a date after vacation, after leave vacation.
Okay, on the prayer, Mr. L. Google and Counsel Board of Petition, is the case on.
Date.
On the prayer is made with the consent of Mr. J.K. Goswami, Learned Counsel Board. That's one number 4 and 5. Not 7 to 15. Item number 37. Okay.
Lordship, item number 38. Interim is there, Lordship.
Interim there.
Lordship.
On the request of Mr. M. Khan.
R. Islam.
R. Islam, Learned Counsel Board of Petition, is the case. What is the subject matter?
Eviction matter, Lordship.
Okay. 2 weeks. No affidavit file?
No, Lordship.
No counter file on behalf of the respondents.
Affidavit will be required, Lordship.
The interim order passed earlier. Shall continue till the next list.
Yes,
Yes, Mr.
I think 51 hearing.
51
Hearing. The interim order operating against us. So
hearing.
after Bihu Mela,
You.
a date may be fixed.
Okay, Mr. A. Bhattacharya, Standing Counsel Revenue Department, has prayed for listing of the case on immediately after the ensuing revocation. Who is for the petition? J. Abbas, Learned Counsel for the petitioners, is present as agreed to by the Learned Counsel for the parties. List the case in May. When?
Any date.
Any date.
No,
If any date.
no, my lordship.
13.
Lordship, item number 46. It is for instructions today, Lordship, regarding the status of the land. It has been encroached by some other party.
40?
46, Lordship.
Yes, what do you want?
Lordship, the instructions, it was sought for, Lordship. If the nature of the land changes, then my writ petition will become infructuous, Lordship.
When do you want?
Lordship,
Tell me.
Lordship next week.
Okay, put it on the prayer, Miss
And Begum.
Begum. Place the case on Wednesday.
Much obliged.
Item number 50, Lordship, interim order is there, Lordship.
Item number 50. Eviction.
Yes, Lordship.
Okay.
And Lordship, and respondent.
Miss
PP Das, Lordship.
PP
Das.
Das. Vegetable. Stands as on for 2 weeks. The interim order passed earlier shall continue till the next.
Lordship, item 51 interim is there.
Yes, service upon respondent number 5 is not as written answered, Lordship. You may-
Decide on after 2 days, 2 weeks. In the meantime, may happen. What urgency Mr. Goswami has? CBS Burman. Already adjourned, is it not? 3 weeks. You want a fixed date? Okay, I'll put it a fixed date. It is not possible, I think.
That is mentioned by the petitioner, Lordship, because
Huh?
that is mentioned by the petitioner.
Right, so you take your choose your date, say 23rd April. Where is I'm putting a fixed date.
In item 51, Lordship, interim is there. Lordship.
51.
Date you Lordship is fixed, Lordship, interim only, Lordship.
Okay, that's interim order.
Obliged, Lordship.